Have your attention, please all rise. Lawrence County Municipal Court's now in session. The Honorable Donald R. Camper presiding. All those having business before the court draw near, and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Good morning. Today is Good Friday, March 29th. Welcome to the Lawrence County Municipal Court. We have reviews, so if you're here and you have a file that's being reviewed, your name's going to be called. Come up to the table to your right and stand there. We're going to go over the file with you. If you don't get called, go check in with the clerk to see why you weren't called. If you missed a hearing before, they're not on the docket today, so you need to check in and let them know you're here. So we'll do the reviews, and then after that, we'll have new cases.
Jason Collier, Cameron Harless, Jonathan Carr, Thomas Jarvis,
Come up when your name's called.
Robert C. Lavelle, Natasha Lynch, Emily McCoy.
Jason Collier, 22275, 22222, 21885. Okay, Mr. Collier, you are at IRS?
Yes, sir.
Where's Mr. Gwen? I saw him here.
He's coming, Your Honor. He was in the urine screen for me. Lawyer.
Sorry, Your Honor.
This is on Jason Collier.
He's compliant.
Let's get a report, get screens. So that's good job on your counseling. Are you working now? What's going on with that?
Yeah, I'm working.
What are you doing?
Running heavy equipment.
You have something to pay on your fines, and you've got restitution to pay too.
Well, I came the other day, but I was unaware this establishment didn't take debit cards, so I will come back.
I want a payment today.
Okay.
There's plenty of ATMs within short distance. What can you pay?
I'll pay $25.
No, we need more than that. You owe $400 in restitution to one of these people, and you haven't paid anything.
I'm aware.
Back in custody.
I can pay.
Going into custody.
Get back here.
I'll see you at the end of the docket. Cameron Harless.
Mount Praise, Your Honor.
Yes. $23.48, Cameron Harless, and he's at RRS for treatment. Okay, it's a pretty good report, but it sounds like there's still stuff that you have to work on in your counseling, so
Yes, sir.
keep working on that. You've got community service to do.
Yes, sir. I started yesterday, and I planned on finishing it next week.
Okay, and announcement for everyone. April 12th and 13th are going to be double credit days because it's a cleanup day, so if you do those days, you get 2 days credit for 1 day work, April 12th and 13th. You got to get out here and get your community service done. Do you have a payment on your fines?
No, sir. I was going to try to do extra community service to start working it off after I finish mine. I've been trying to save for my SR22 to get my license reinstated.
Okay. April 29th will be your next hearing. April 29th, 9 a.m. I want to see some community service in the next month.
Yes, sir. Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome. Jonathan Harr, 16-926. Jonathan Harr is not finished. What he was ordered to do has not appeared today. He gets a warrant for his arrest. Thomas Jarvis, 23-972.
You said those 2 days were the 12th and the 13th?
April 12th and 13th. It's a Friday and Saturday. You've got quite a bit of community service to do.
Yes, sir.
You did make a pretty substantial payment today on your fines.
Yes.
And you were supposed to be going to Prestera.
Correct. So I've done my assessment through Prestera, and I had my first appointment with them yesterday. But it had it had the counseling, and then underneath, under the special instructions, it just said assessment from Prestera. So I wasn't sure if they just needed to send that over and go by their recommendation, or if I needed to go through with the counseling.
Yeah, well, assessment means you go to them and you give them a history and they decide what you need, and then I need to see what they set up for you.
Okay, so the guy that I talked to yesterday, he's going to call me at around 11 or noon. So I'll have him send over my assessment.
Yeah, and that needs to be filed with the court, because this was a second offense.
Correct.
And you're required to have treatment, but here's the other thing. Were you honest with them about your history?
Yeah, they know about the 2 DUIs
Okay.
and
And
everything.
if they come back to me and say, it's not going to be very believable if they come back to me and say, oh, he's had 2 DUIs, but we don't really think he's got a problem.
Okay.
That's not going to be believable.
I understand.
Okay, so there needs to be some counseling done.
Okay. Well, like I said, I've already started. I had my first appointment yesterday, and if I need to go ahead and continue with it, I'll still have them send my assessment over.
Yes, you need to continue with it.
Okay.
Okay, April 29th will be your next hearing, and bring a report from Prestera the next time you come.
Okay.
And let's go ahead and proactively have him sign some sort of release, because that's what I anticipate. They're going to say, well, we don't need a release. I mean, you're the one releasing the information, but we want you to sign something saying we have a right to get the information. So,
Okay. Well, I did tell them it was court ordered, so they're
yeah.
aware.
Some of them are fine, they'll just send it then, and others will say, oh, we got to have some kind of confidentiality waiver. So,
Okay. So I'll get that up front.
we've got one. Mr. Cooper will help you get that signed.
Awesome. Thank you.
Robert Lovell. Robert Lovell is 22672, and he's done nothing on his case, so he gets a warrant. He hasn't appeared. Natasha Lynch. And that, you're Natasha, I take it. You're not?
No.
What's your name?
Emily McCoy.
McCoy. I don't think we called you. Did we? I don't have a file for her. File got Natasha Lynch. Natasha Lynch, is she here? Natasha Lynch has not appeared. She hasn't done anything on her case, so there will be a warrant. All right, just have a seat. We'll find your file. I don't have it
Thank you.
right now.
State of Ohio versus Glenn Gibson Jr. 10-1078A and B, TRC 10-2432A, B, and C.
All right, Mr. Davenport's representing Mr. Gibson. This is an older case, an OVI, and there's hasn't been much done on it. There was a payment made today. So what say you, Mr. Davenport?
Your Honor, Mr. Gibson was out sick for about a month from work. He wasn't able to do community service. We've discussed it, and intending to be back. I don't know if he's going to be able to make it for the double credit days, but he is intending to step up his community service. We'd also ask, he's working full-time over in Milton, West Virginia. And when he realizes he has to come to court regularly to report, but he's losing about a half a day of work each time. We want to see if we could stretch out the intervals a bit.
Your Honor, if I may, I did look him up this morning. He's done 1 day since his last hearing. I don't know if it's in the file.
Okay. Well, how do you want to proceed? I mean, we need to set this for a hearing. I mean, he got arrested on a warrant for failure to appear and pled not guilty to the failure to appear. So that's still an issue. Is he, we need to have a hearing on that, or how does he want to proceed?
And he'll enter a plea today on that.
So he admits he failed to appear, because it looks like this was an old case. He got sentenced December of 2010 and had some review hearings that he did appear for. Until January of 2011, he failed to appear. I'm sorry. Well, it looks like he failed to appear then, but I think he came back. And the last hearing that he failed to appear for was in September of 2011, September 30th, 2011. He failed to appear, so he was out of pocket for 12 years, from September 30th, 2011 until he got arraigned on the warrant, December the 15th of 2023. So.
That's all correct, Your Honor. He got picked up and he did some time in jail before he could get down here. And lots changed over the last 12 years. He's aware of his the need to satisfy his obligations to the court.
Okay. All right, well, what I'm going to do, I'll just delay sentencing on this. I'll accept his guilty plea. The main thing I want to see him do is just finish what he was ordered to do to begin with. He's got quite a bit. He's got a bunch of community service and fines and costs to pay. So let's make an effort to get that done.
Your Honor, is there any possibility that some or all of the community service could be converted to fines?
I've never done that before in 30 plus years.
I understand.
I've never done that, so I'm not going to start now.
I understand.
I mean, actually, I could give him more, because if it's really not fair to somebody that had another case in 2010 and did it in a timely manner, then he takes 12 years off and then comes back without some kind of penalty for it. I mean, did he have any, let's put it this way, is there a good excuse for not being here for 12 years?
No.
No?
There's
Okay.
not.
It wasn't like, it's a legal excuse if he was in prison or something like that for 12 years, because you can't be in two places at once. He's confined, but he just didn't appear, blew it off. Now he's actually he's got a bond up now.
Yes.
So I'm going to put it on the sentencing docket, and I'll determine it at some point. But yeah, it's inconvenient, but it needs to be inconvenient. That's the least of it. So I'm going to set it for April 29th as his next hearing. What he could do, if he wants it not to be so inconvenient, is go borrow some money and pay it off. If he can't pay it all at once, go borrow money from somebody else, a bank or whatever, pay it off, get his community service done, and then he wouldn't have to worry about it anymore. But until then, he's got a sentencing hearing April 29th at 10 o'clock.
Thank you, Your Honor.
You're welcome. On Emily McCoy, it was erroneously placed on the review docket. You're actually on the sentencing docket because you have a bond up. So we'll call you when we get to the sentencings. So you are on the docket, but not for review.
Thank you.
You're welcome. Okay, that finishes the reviews we have to do today. We're going to start the arraignments now. So arraignments are for People have new charges.
Courtroom now, arraignment.
We need them to come in the courtroom now. If you got an arraignment, or if you missed a case before and have a warrant, and you want that withdrawn, you need to be in the courtroom now, and you need to let the clerk know you're here, that you want the warrant withdrawn. So they'll put it on the docket. So come in and have a seat so I can give you instructions on your rights.
Everybody needs to have a seat now. Don't care. Have a seat. Just sit down.
I'll come back here.
Okay, let's listen up so we can try to get over this once, but I'm happy to go over it again with you if you're confused, don't understand what your rights are. You've heard this at least 100 times if you've watched any crime shows on TV, because it comes from a very famous case, Arizona versus Miranda, where the U.S. Supreme Court says people have a right to be told what their rights are before they make statements. So you have a right to remain silent. You don't have to say anything. But if you do say things, what you say can be used against you. Everything we say here is all being recorded, even now on video. So it's not just your words that are being recorded, your image is being recorded. So if you get up, and I've had people do this, the first thing out of their mouth is, yeah, I did that. Well, you know, the prosecutor can play that to a jury if you want to have a jury trial, that you admitted you did what you're alleged to have done. You have a right not to say that. You have a right, you can't be forced to testify against yourself. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to bail, and you have a right to make the state prove any charge against you beyond a reasonable doubt. So, those are your rights that all defendants have. If you get up and tell me you're pleading guilty, you're waiving those rights. We're not going to give you a lawyer if you plead guilty. We're not going to have a trial if you plead guilty. Or no contest. Either one, you're waiving your rights. You should not waive your rights if you don't understand what's happening. If you're confused, this doesn't make any sense to you, don't enter a guilty plea because you want to get it over with. I have people tell me, I just want to get it over with. That's not a good reason to enter a guilty or no contest plea. If you want to talk to a lawyer, if you want a trial on your case, or if you don't know what to do, you should enter a not guilty plea when you're asked for a plea. Call the first case.
State of Ohio versus Alec R. Berry, case number TRD 24611. Alec Berry.
Alec Berry.
Your Honor, I assessed Mr. Berry yesterday. I think he was under the impression he didn't have to be here till the 18th.
I'm looking at his citation, March 29th. It was ordered into court on March 29th at 9 a.m.
Okay, my apologies, Your Honor.
So you can tell him he needs to get in here because I'm going to issue a capias to the OSP for his arrest for not appearing. So the smart play for him would be to show up Monday morning at 9 a.m. for his, and avoid getting arrested.
Yes.
State of Ohio versus Kyle White, case number TRD 24599, A and B.
Okay, sir, are you Kyle White?
Yes, Your Honor.
Mr. White, it's alleged on March 23rd at 2:02 a.m. in Perry Township, Lawrence County. It's alleged you were driving a vehicle while you were under the influence of either alcohol or drugs. And it's alleged this is the first time, at least in this state, you've been charged with this offense. On a first offense, the maximum penalty you face is 6 months in jail, a $1,075 fine, and a 3-year license suspension. That's the most that can happen if you're found guilty. There is a minimum. Most charges don't have a minimum, but this one does. The legislature doesn't trust me not to give you an appropriate penalty, so they say, Judge, this is the least you can do if the guy's found guilty or lady. 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the least you can get if you're found guilty. You're also charged with driving outside your lane. That's a minor misdemeanor. The maximum penalty is a $150 fine. So those are your two charges. Do you understand them?
Yes, Your Honor.
Do you understand the rights you have that I explained that
Yes, Your
defendants
Honor.
all have? How do you wish to plead to this charge?
Not guilty, Your Honor.
Do you want a lawyer appointed to represent you?
No, I can afford one.
Okay. Let me tell you when we're probably coming back on your case and see if that's enough time for you to get a lawyer. Probably April the 22nd or after.
May I check my work schedule?
Yes, sir.
Okay.
I can make it, that's a Monday. I can make it a Friday.
I think
Our
I've
court's
already
either
got-
Mondays or Fridays.
Okay. So would that Friday be the 26th?
26th, probably, yes. That's
Yes,
good?
yes, sir.
Okay. I'll set your next hearing for April 26th. That's going to be a pretrial, what we call pretrial, at 10 o'clock. I'm putting down that you will hire an attorney. I'm going to let you, you didn't post a bond.
No, Your Honor.
I'll let you sign what's called a signature bond at $1,500. So what this means is like you're signing a promise to come to court. As long as you show up, you don't have to post the money. If you don't show up, then you get a warrant and you have to pay the $1,500 when you're arrested.
Yes, Your Honor.
You have any questions?
No, Your Honor.
Okay, that's all. April 26th, 10 o'clock is your next hearing.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Donnell Hall. Case numbers TRD 22-175, TRC 21-371 A, B, and C, CRD 21-103.
All right, ma'am, are you Donnell J. Hall?
Yes, Danielle.
Danielle. Okay, 20, you've got several cases here. One's a new one. 24610 is the new case number. That one alleges that on March 26th at 5:02 p.m. in Union Township, you were driving with a suspended license. That's, the section you're charged with is what's called an unclassified misdemeanor. Maximum penalty, there's no jail time, so that's the good news, but there is possibly up to 500 hours of community service and a $1,000 fine. You understand that charge?
Yes, Your Honor.
Then your old cases are case number 220175. And that was also a driving under suspension. It's alleged you failed to come to court when you were ordered to. And this is a case from January of 2022, January 23rd, 2022 at 10:40 a.m. in Union Township that you were driving with a suspended license, same statute. So it's an unclassified misdemeanor, maximum penalty 500 hours community service, $1,000 fine. So that's still pending, and from my records, it looks like you never came to the arraignment, so you didn't enter a plea on that. How do you plead to that charge?
Not guilty.
Then case number 21371 was an OBI that you got convicted of. Conviction was May 7th of 2021, operating a vehicle intoxicated. You had a review hearing on September 27th, 2021, and it's alleged you didn't appear at that hearing and got a warrant for it. So that's been outstanding. And the first time you got, I don't know how you got out of that first one without getting taken to jail on the warrant, but
They
somehow
said the
you
jail
escaped
didn't.
it.
They said the jail didn't want me because of the COVID.
Okay. Then the second time, they did want you.
Yeah, I had COVID the second time when I got the other, driving on suspended. I had COVID that time.
So this time you had to post a bond again?
Yes, I did, Your Honor.
Okay. So those are the charges against you. Do you understand those charges?
Yes, Your Honor.
Okay. Well, here's the thing. The last two charges you have are actually non-jailable offenses. So you're welcome to have a lawyer on those, but I can't appoint a lawyer for you because I can't put you in jail on those. I could put you in jail on the old case for failure to appear at your review hearing. So I'll ask you on that. Do you admit or deny you failed to appear at your review hearing back in September of 21?
I admit.
Do you have was it COVID was the reason?
Yes.
Okay.
I don't have no good excuse as to why I haven't been. It's just out of fear.
Okay.
I've just got a really good job, and I, just out of fear, just didn't come back of what would happen.
Well,
It's not a good excuse.
no, it's not. And just from my experience, of course, I'm here all the time, and
Yeah.
I know it's always better, and I think it applies not just to this court, to just about any court that you go into. If you mess up, it's better to come to the court on your own and say, Judge, I messed up, and I'm here, I'm going to face the consequences, and I want to do better, and I'm turning myself in, rather than get snagged by the back of the neck and drug into court. That never looks good.
No, it
At least the
doesn't.
judge can say, well, I think they've had a change of heart, maybe. They want to do the right thing. But anyway, so now you're here with a bond. So
Yes,
now it's a big difference. So let me explain the difference. Before, when you didn't come to court, I issue a warrant.
Yes.
That goes out all over the state of Ohio. But guess what? And maybe I need to keep this quiet. None of those sheriffs in those 88 counties are going to go actively looking for you on a warrant for not appearing on a review hearing. They're just going to wait till you have police contact like you did, and then you're going to go to jail.
Yes.
But now it's a different ballgame because you've got Mr. Sowards. Do you know Mr. Sowards?
Yes, I do.
Okay. You know him very well?
Not really well, but
Well, he posted
my
a-
boyfriend does know him really well.
He posted a $4,000 bond for you.
Yeah.
$4,000. Gary Sowards would go to the gates of hell and come back for $4,000.
Oh, I know. He knows where to find me.
So it's not going to be like the old days. If I issue a warrant, he's just going to lay out there until you have police contact.
Yeah.
If I issue a warrant, he's going to be out the next day looking for you.
I won't
He's
miss
going to
it.
nab you and take you to the jail.
Absolutely. He made
Because
that very
he does not
clear.
want to pay the $4,000. He has to, if he can't find you, he's got to pay the court $4,000. He never forfeits bond.
I bet he
because
doesn't.
We've had him go.
He said he just got back
goes
from.
anywhere to
Yeah,
get
he said he
people.
just got back from Georgia getting somebody.
Yeah. So the point of that story is you've got to come to court now,
I will.
unless you want to go back and visit the jail.
I do not. That was the first time I'd ever missed court, and it won't happen again.
Okay. All right, so if you want a lawyer, you can get one, but I can't appoint one for you.
Yes. I'll probably have to get one.
Okay, well, there's several around. There's a bunch here today.
Okay.
How much time do you want to get that done?
How much time do you normally give?
Well, I'm looking at probably April 22nd.
Okay, that'll be fine.
Your next hearing on all these cases is going to be April 22nd. That's going to be a pretrial. You've got a bond up now of $4,000. And I'm going to say, because this was an old OBI, you're probably eligible to get your license back now.
Yeah, well, I have something in West Virginia as well, so I'm waiting on my tax return to get all that taken care of, and then I'll be able to get my license back.
Here's what I would do if I were you, what I'd advise you to do. You need to get in touch with the Ohio BMV and say, I want to get my license back, what do I have to do? And you can actually now go to the local offices. Either
Okay.
the one in Proctorville or the one in Ironton, they're supposed to help you with that, walk you through what you need to do.
Okay, appreciate
And
that.
come back on April the 22nd with some information.
I will.
Don't just wait till April 21st, and then try to call the B&B, because you won't get them on the phone.
I'll probably go today because that's
Go
the
today.
only time I have
Be
free at
proactive.
work.
Start working on it
I'll
now.
go now.
Okay, do you understand what you need to do?
Yes, Your Honor, I do.
Okay, 10 o'clock, April 22nd.
10 o'clock.
Yeah, write that down. April 22nd, 10 o'clock, your next hearing.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus Chad D. Campbell, case number TRC 222782, A and B.
All right, Mr. Campbell is here. He had a review hearing set for Monday. Is that right? No, it was a week ago. Last Friday.
It was Friday.
You have paid your fines.
Yep.
You still have community service left to do.
I believe I have 4 days, so if I can go to the April 12th and 13th, that should get it all done.
I think you're right.
Yeah.
Okay, I'll set it next hearing. So why weren't you here on the 22nd?
Is that last Friday?
Yeah.
My daughter has really problems with her stomach, and she has to go Monday to have a consultation to see if she needs surgery or not.
Okay, so your daughter was sick is what you're telling me.
Yeah.
April 29th, 9 o'clock. If you get it done before then, you don't have to come back for the hearing. Just confirm with either Mr. Cooper or Mr. Major that you've got your community service done and you don't have to come to the hearing.
Okay.
Okay?
Thank you.
April 29th, 9 o'clock.
Thank you.
You're welcome.
State of Ohio versus Buford Jones, case number TRD 202767, A, B, and C, and TRD 201795, A and B.
And you're Buford Jones?
Yes, sir.
And you got it picked up on a warrant for failure to appear for a review hearing on, looks like 3 files. 202767, 201795, and 2016. And it looks like, and you've posted a bond now
Yeah.
with Mr. Sowards. I don't have to give you that speech about
Yeah, I heard you.
how relentless he is
Yeah.
about picking people up. And all of your cases were driving inspections. Is that right?
Yes, sir. But
Okay.
when I come here last time, when I went in front of you, I think it was what, 22? I was in felony court, and you just said, I didn't get no other court day, so I had to go to felony court. Well, I'd done 6 months in jail, and then I went to rehab, and I've been clean for 2 years now, but I've been out not very long. So
Okay, so what I'm showing is you had a review hearing November 22nd of 21. That is what you didn't appear for. Were you in custody?
I was in jail then I went to rehab. So I graduated rehab too.
Where'd you go to rehab?
UFR in Ironton.
Okay, I'm not familiar with
United Family Recovery.
I don't know that one.
Oh, you don't know it?
So are you done with common pleas then, or are you still working with them?
I'm still felony court. I'm still.
Okay, I'll withdraw the warrant since you are here now and you've got a
Yes.
bond up, so with
Yes.
Sowards. So I'm going to set it for a sentencing hearing, and let me just go over what I'm showing you up.
Okay.
6 days of community service and fines and court costs, about $1,000 between the 3 cases.
Gotcha.
So you heard about the double day,
Yeah, the 12, 13.
12, 13th, you can get double
Yeah.
credit, and it'll go, you only need 6 days, so that would give you 4 of the 6 right there.
Okay.
Do those 2 days.
That's the 12 and 13th, right?
12 and 13th. Be here, you come to the court at 7:30.
7:30.
Yeah, and you'll be going to Fayette Township.
Okay.
Okay, your next hearing is April 29th. And it'll be a sentencing, because he's got bond up now.
Okay.
10 o'clock on April 29th.
All righty. Thank you, sir.
You're welcome.
State of Ohio versus Harold Moore, Case number TRC 23-1259, A, B, and C, CRB 20-550.
Moore is here.
Sorry, I need that one.
Okay, I'm showing that you missed a pretrial back in November.
Yeah, I had a warrant in West Virginia and was picked up on that.
Okay.
And
Mr. Scott was your attorney?
yes, I talked to him and he told me to come here and take care of this. He'd be out of town for a while.
Okay. So you're telling me you're Western Regional or someplace?
Yeah, I was in Western Regional for 4 months. Called and got a bed in the Lifehouse recovery program and
Okay.
currently there on home confinement.
And you're from Lifehouse?
Yes.
And that's where Mr. Webb's working now?
Yes.
Yes,
I got a text from him.
he's my recovery coach.
Okay. I'll cancel the warrant, and I would say, do we know, he's in the reserve, short reserve or something, I don't know if he's out of
Usually
town.
gone for 2 weeks.
He told me he wouldn't be back available till the 5th of April would be the soonest
Okay.
he'd be available.
That's not that far off. I'm gonna, let's go ahead and put you down for them. He can be here April 5th?
That's what he told me he could, yeah.
April 5th, we'll put you down for that date. It'll be a pretrial at 10 o'clock. I'm making you note you're at Lifehouse now. I'm ordering you to stay in that program and complete it. You probably won't be finished by the 5th, but I want you to stay there and then show up for your hearing on April 5th at 10 o'clock.
Thank you, sir.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Stephen Boyd, case number CRB 24-164.
Yep.
Mr. Boyd, you were just handed a copy of the charge. It's a failure to confine a dog charge. It's alleged on March 23rd in Fayette Township, you were the owner of a dog that you failed to keep, physically confined or restrained on your premises. That's a minor misdemeanor. The maximum penalty is a $150 fine. Do you understand the charge?
Yeah,
You understand your rights?
yeah.
How do you plead?
I don't even know what to plead with it. I mean, they didn't do nothing.
Well, I'd say that's a not guilty plea. If you say you didn't do anything, so that's a not guilty plea.
Would I have to come back, like in the
Yes, sir.
future?
Set it for a trial, if you want a trial on it.
Now I'm guilty, just go ahead and pay the fine.
Okay? If you enter a guilty plea, you're admitting it's true, and you're waiving your rights to have a trial. Do you understand that?
Yeah, let's go ahead and get it done, yeah.
Okay, it's a very lengthy affidavit. I'll try to shorten it up a little bit here, but it's a Deputy Frame wrote this affidavit. It says March 23rd, dispatched on an animal complaint. The neighbor's dog down the hill was in his yard. Advised the dog continued to be aggressive. He couldn't let his dog out. Got into a yelling match. They didn't charge us any threats, but it says there were threats made. Went and talked to the owner, which I'm assuming is you, Stephen Boyd. Advised me he woke up around 10:30, 11, let his dogs out. German Shepherd, brown smaller dog. Went inside to fix breakfast, started to hear screaming, observed neighbors yelling. Mr. Boyd advised Mr. Kerman, then proceeded to threaten his dogs. Said this is the first time this has happened. Okay, so they gave you a citation.
Yeah.
Okay, well, do you have any explanation or statement you want to make?
Well, I finished my fence yesterday, so that they're
Okay.
confined now. They're puppies, they're not mean. They've never hurt nobody. My 4-year-old's not even scared of them. But I got everything taken care of. They're confined, they can't get out now. I let them out, they're in the fence, so.
Okay, well, that's the way it's supposed to be. I know a lot of people think I can just let my dogs out and let them run. I've got a neighbor that's got a pit bull that runs the whole neighborhood.
Yeah.
That's a violation of law. We have a leash law in this state. You have a dog, you gotta keep it on a leash or a fence or somehow keep it confined to your property. It's not supposed to be in the street. It's not supposed to be in your neighbor's yard. It's not supposed to come in your neighbor's driveway or run in front of bicycles as they're going down the highway, which happens, or motorcycles. I mean, it's actually dangerous. So, keep your dog out.
Oh, yeah. I done told the wife all about it. Outside in the backyard only, never in the front yard no more. That's what happened. They went out front and they took off.
Okay. I'll impose a $50 fine, which I'll suspend on the condition that we don't have any further citations. I'll order you to pay the court costs, which is bad enough. So do you need time to pay that? Can you pay that?
How much is it?
$125.
I can go pay that now if you want to.
See, the clerk, right, as you leave the courtroom and your case is done. No further
Thank you, sir.
action. Just don't keep them up.
Thank you.
State of Ohio versus April Bradley, case number CRB 24165. April Bradley.
Are you April Bradley?
Yes.
And you are April Bradley, ma'am?
I am.
Ms. Bradley, it's alleged, it's another dog case. March 22nd, so this is a different day. Fayette Township, it's alleged you allowed the dog to run loose without being confined or on a leash. That's a minor misdemeanor, maximum penalty is $150 fine. Do you understand the charge?
Yeah, I understand it.
You don't have to agree with it, but you
I don't.
understand it. You understand your rights.
Yeah,
How do you plead?
not guilty.
Okay, I'm just gonna set it for a trial then. I'll set it, because I have to set this within 30 days.
That's fine.
You work
I do.
Mondays or
I'm
Fridays?
missing it right now. Huh?
You have a,
Monday through Friday, yes.
okay.
Or
well,
actually,
I
Monday
have to
through
set it
Sunday.
on a Monday or a Friday, that's when we have
That's fine,
work.
anytime.
Either one, it doesn't matter? Okay, I'm gonna set it for Monday, April the 8th. So that'll be, and I'll set it at noon, so you, otherwise you'd sit here and watch all these other proceedings where there's no evidence. So we set the trials at noon. So April the 8th at noon for a trial. So if you have witnesses you want to testify, you need to get, you can actually compel them to come. If you don't think they'll come on their own, you can have a subpoena issued
I got
from
one
the
with you
clerk's
right
office.
now.
Okay. Well, the state has to get notice that we're going to have the trial, so they're not ready for a trial today. So they'll have they should have their witness here on April the 8th at noon.
And can I ask some questions? Would this
Yes,
be okay, I don't even know the person's name. All I know is my dog got shot and killed.
You can you can get a copy of the complaint. You should, well, you just got handed a copy of the complaint.
Oh, okay. I'm not used to being
The complaint has
placed.
an affidavit. Is there an affidavit attached to it? It's 2 pages long.
Okay, well, I can read that
It's got
later.
the person's name, Napier. So that's all in the affidavit as to what's being alleged against you. Any other questions?
The sheriff that was involved, is he gonna be here? I would like him to be here because he has pictures.
Okay, well, he might be, but I don't make that decision. I just hear the case. The prosecutor has to get the witnesses here that they want. So if you want him here and you're afraid they won't bring him, you could go have a subpoena issued from the clerk's office
For the sheriff?
for the deputy.
For the deputy.
You don't want Mr. Lawless here because he knows nothing about this. You want the deputy that came out and investigated.
Yes.
And his name is on the affidavit.
Okay,
Any other questions?
I think that's it.
Okay, that's all. April the 8th at noon.
Thank you.
You're welcome. Okay, that's all the arraignments, at least that we have right now. There might be more coming. Is there processing the paperwork? But we're going to start the pre-trials now, so I need the prosecutor and the lawyers and any of their clients that have pre-trials need to be in the courtroom, not out smoking or whatever they do.
State of Ohio versus Patrick Murtha, case number TRC 24241.
All right, this is Mr. McCown's case.
Good morning, Your Honor.
Good morning.
Your Honor, I have spoken with the prosecutor. They did, not the prosecutor, the state agency finally did provide that information for which we had filed our motion to compel. That actually begets a request for additional information for dispatch logs. Mr. Heald has indicated he can get those to me forthwith. I think it's just going to be, at that point, a matter for a suppression, according to Mr. Heald. It's an odd duck as far as facts go, and that supposedly on one of the standardized field sobriety tests on the HGN, it was 6 of 6, but it was 0 of any other clues on all the other tests from it. So,
okay. So you want to just go ahead and set it for a hearing now?
Probably that would make the most sense. And then if an issue arises as to them providing the information, we can bring that to the court's attention before then.
Mr. Heald, do you agree with that, or?
I'll do whatever is required. We're going to get another item of discovery, the dispatch logs from this time period. And I don't know whether you're going to draft your motion before you get those or not.
I will not, no, because I'll need those.
And I don't know what difference
that
that
might
might
be.
make.
Pre-try the motion then. Let's get the motion filed, pre-try it, and then we can, if it's not resolved, then we can set it for.
That's fine, Your Honor. Sure.
So when will the logs be turned over?
It will depend on how quickly the Highway Patrol gets them to us, but I don't think it should be more than a couple weeks.
Your Honor, I'll be here on the afternoon of the 15th for a suppression hearing.
Okay, we'll put it down for a pre-trial suppression for April 15th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Brian P. Smith, case number TRC 231421, A and B.
All right, this is a case set for pre-trial, Mr. McCown's case.
Thank you, Your Honor. Your Honor, it's fine. This is when we had a suppression hearing before the court. This is one that Mr. Smith has indicated to me that he wishes to change his plea on this matter and enter a plea of no contest. This is the one where he had indicated to the officer that he had a TBI as a combat vet that affected the other's tests, but he has indicated he wishes to plead no contest to that, is my understanding.
All right, do you wish me to read into the record the report of the officer?
I don't believe it's necessary, Your Honor.
All right.
I believe there's we would stipulate to a finding of guilt if that's the court's inquiry.
All right, Mr. Heald, do you have any statement or recommendation you want to make to the court?
Your Honor, it's a first offense. We don't have any opposition to it being treated with the minimums as far as the suspension of the jail sentence and the 3-day driving school. We don't take any position on the amount of the fine, 6-month driver's license suspension.
We would ask that be run retroactively, Your Honor. I think this is an October present, Your Honor, for the...
There was a test here, as I recall, right? So it would start at the time of the offense.
And Your Honor, he has already taken the 72-hour DIP program at Crossroads Recovery Services. I've shown that to Mr. Heald, if I may approach.
Okay. we have, we'll need that filed with the court also.
Okay.
We have a copy filed with the court, please. All right, and Mr. Smith has a right to make a statement to the court if he wishes to.
I apologize, Your Honor. I was wrong.
Thank you for that.
I was having a bad day. Just got divorced too, going through a divorce, so. Lapse of judgment.
Okay, on the fine, I'll impose a $600 fine. Order that the cost be paid. 6-month license suspension that started the date of the offense, so your suspension is going to be over tomorrow. You will have your 6 months in tomorrow. So what you need to do is contact the B&B. It doesn't automatically reinstate. There's going to be things you have to do to get it reinstated, but you'll be eligible to do that very soon to get reinstated.
Yes, sir.
20 days in jail, all suspended on the conditions you do 5 days of community service. I'll find that his DIP program's already been completed prior to today, so that won't be required. I'll set his, I don't have a note on the September.
9/27/24 is what's.
Okay. September 27th will be your review hearing, so that gives you all summer to get everything done. If you do, you don't have to come for that hearing. It's a hearing to check to see if you did what you're ordered to do. It'll be at 9 a.m. on September 27th. On the speed offense, I'm going to impose a $150 fine because it was pretty unreasonable speed. No, just one court cost. And he'll need to check in with Mr. Major before he leaves today. And any questions?
Nothing further, Your Honor.
All right, see Mr. Major, he's free to go after that.
Thank you.
State of Ohio, this is Ryan T. Evans, case number CRB 23723, PRC 231777, A and B.
This is Mr. McCown's case, and I have it set for a pretrial.
Your Honor. Your Honor, Mr. Hill and I have discussed this at length. I believe that we're going to end up potentially working this out and coming to the court with a potential resolution for the court to approve or disapprove. What I'd like to do, I think he's going to check with an employer about some certain aspects and how things would affect him in this case. So if we could do it, we can go ahead and set, if we could go ahead and set the motion date and hold it, that way we don't have to come back to do it, and then we'll do a pretrial a couple weeks before. We don't have a motion on a date on the motion for this one. I don't want to come back and then if everything falls apart to say, gee, sorry, Judge, can we set a motion?
Okay, well, is there a motion filed? I don't see.
There's not been one filed. We thought we were going to work this out. So, is that correct, Mr. Hill?
That's what I have been receiving from you, that there's a potential way to include this, but you were going to file a motion?
Yes. Well, the court will require us to file a motion. Obviously, if we work it out prior to the motion date, I won't sandbag Mr. Hill. I'll get him the motion a couple weeks before our motion date if it's not otherwise worked out.
That's fine.
If that's okay with the court. If not, I'll of course follow the court's directive on that.
All right, I'll set it for April 26th at noon for a motion hearing.
Thank you, Your Honor.
You're welcome.
Is that going to be for evidence then?
my understanding. Do you want a pretrial date before then, or can you? Sometimes lawyers need to be forced to talk.
No, I think, I don't.
They say they're gonna do stuff, but then it never happens until you make them do it.
I think the court has slapped my wrist enough, Your Honor. It'll be filed.
All right, I'll just set it for a motion hearing April 26th.
Thank you.
State of Ohio versus Travis L. Black, case number CRB 23743.
Mr. Morpher represents Mr. Black, and this is basically for entry of an order. He's at Bethesda, and I've been getting reports that he's doing pretty good with this. So,
Yes, Your Honor.
I think that's going well. Appalachian Regional, and I don't think we've ever had to do this before, but they sent an order that they wanted entered before this could go forward to them, so I sent you a copy of that, Mr. Morford.
Yes, Judge, I'm in agreement with the entry.
Okay, would you come get it, and you and Mr. Hield sign it, and then we'll send it up to them. Morford's the same word, he yesterday.
I know, Judge.
So you should
I
have
had
read
trouble
it
seeing it
in the
though on
courtroom.
my phone with the screen.
All right, I'll enter this order, and the clerk will deliver it to Appalachian Regional. Now, let's set another hearing just to make sure we don't lose this case.
Your Honor, it's
Okay, let's just keep that day. So we'll keep the day. He has already a hearing in place for April the 8th. We'll keep that day.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Gary Calico, case number TRC 24519, A, B, and C.
Morning, Your Honor.
Good morning. Mr. Pascamp, correct?
Yes, Your Honor.
All right, this case is set for pretrial today. I think this is the first one.
That's correct, Judge.
Filed a notice of appearance on March 21st. What can we do today to get things moving?
Thank you, Your Honor. I've spoken with the prosecution on this. We were going to set this out for another pretrial, need a little more time to review discovery and try to discuss a resolution before the next hearing.
Okay. I'm looking at probably April 22nd or thereafter. So any date, April 22nd or after is good with the court.
If Friday, April the 26th would be okay with court?
It is. And if this is just going to be on legal issues, if you want to appear by teleconference, I'll allow it.
Thank you, Judge. I appreciate that.
So why don't we do this, because usually for those, we set them a little later so you don't just sit there watching court.
Sure.
Let's set it for noon on April 26th, and we should be pretty close to getting you in around that time. And if Mr. Calico can just be available by telephone, or if he wants to, anybody can. We're actually on YouTube now, so
yes,
to some people's chagrin. But he can watch or be here in person, sure. or appear by teleconference, or be in contact with you by phone. We just need to be able to reach him. So it'll be a pre-trial at 10 o'clock, April 26th.
Mr. Haskamp, have you filed discovery?
Yes. I did get all of it, yeah.
Okay.
Or I think I have all of it.
If you have any problems getting the video or anything, let us know.
Okay. Great, thank you.
PM, April 26th for pre-trial.
Hey, Judge, anything else?
No, that's all.
Thank you, appreciate it.
State of Ohio versus Robert E. Hensley, case number CRB 23-324, CRA 21-345, CRB 21-346, CRB 21-222, CRB 21-114A and B.
All right, Mr. Hensley is represented by Mr. Morford. Is it OVP?
Yes, sir.
Christina Burson.
Need you to sign this. We'll redo it. I was at the TCAP, I did Butler County. Butler County. Please say.
It's a very good report, Mr. Hensley. Good job.
Thank you.
So he's probably going to be getting out around mid-April, I would think.
Yes, and he is planning on continuing to further treatment as well, so.
Very good. I think that's the right plan.
I'm gonna go to Cardinal, sir. I've already talked to Cardinal, and they got me scheduled to pick me up at 1 o'clock after graduation.
What's the day of your graduation?
April 15th.
15? Okay, why don't we come to court that day, and then we can finalize, just make sure everything's on course to make that work that day. So I'll set your next hearing, or assuming Mr. Morford's available then. April 15th?
Yes, Judge.
April 15th will be your next hearing, sir. Good job so far. Keep it up.
Thank you.
Thank you, Your Honor.
You're welcome.
Thank you, Judge.
You're welcome.
State of Ohio versus Wesley A. Earls, case number CRB 2497, CRB 2488, A and B.
All right, this is Mr. Steyer's case. It's on the docket today. Also, I've got a date for April 22nd.
Yeah,
So
I didn't have it on for today, so I did not tell Mr. Earls to be here today, so I would ask that his attendance be excused.
I know he's got an evaluation set up for court, whatever court plan goes by now.
Right, he's got an evaluation set on the 9th, we're set back here on the 22nd. I don't know if we'll have the results back by the 22nd, but we'll at least have had he will have done the assessment, and we'll go from there. So I would ask you to keep that date of the 22nd, and then.
But as far as his living arrangements, everything so far is working?
I've not received any report of problems. I'm assuming that if the state had, I'd have heard about it.
Yeah, we haven't heard anything, so.
Okay, no news is good news in this situation. So April 22nd will be the next hearing at 10 o'clock.
Thank you.
What date is his evaluation?
The 9th.
And is he going to have to travel there?
I'm not certain if they're going to do that by video or by travel.
Okay, we've got some hearings at the jail. We're going to start now by teleconference.
State of Ohio versus Todd D. Hicks, case number CRA 24163.
All right, sir, are you Todd Hicks? Mr. Hicks, I'm Judge Capper. Can you hear me okay?
Yeah.
I'm the judge at the Lawrence County Municipal Court, and your hearing is being conducted here in this court, which is located in Chesapeake, Ohio. It's all being recorded, both the video and the audio are being recorded. You have a right to remain silent. You don't have to say things. If you do make statements, they're going on the record and can be used. This is what's called a Rule 4 hearing for you. So the allegation is that the Court of Common Pleas of Franklin County, Ohio, that's Columbus, Columbus is Franklin County, has a warrant for you in case number 22 CR 1765. Well, let's say for a Todd D. Hicks is what the warrant says. Date of birth, January 28th. and it's on a felonious assault, domestic violence, and endangering children, they say. So what happens in this state, the law is, if there's a warrant for you in a county that is not touching the county where you're found in, fancy word for that is contiguous. If it's not in a contiguous county, then you have a right to have a hearing to make sure that we're not sending the wrong Todd Hicks to Franklin County. So you can have a lawyer, you can have one appointed if you want one, and if you qualify to have one appointed because of your financial circumstances, you wouldn't have to pay for it. But the only issue at this hearing is going to be, are you the Todd Hicks that Franklin County says they want, and is there a good reason for me to send you there? It's not going to be, I'm not going to conduct a trial on the felonious assault, the domestic violence, or the endangering children. That will happen in Franklin County if you go there. You understand that?
Yes, sir.
Do you want to have a Rule 4 hearing, or do you want to agree to go to Franklin County?
I agree to go to Franklin County.
Okay, so what I'm going to do, I'm going to send a waiver down to the jail for you to sign saying you agree to go to Franklin County. Let's see if they say what kind of bond they want. They don't say, so state taking, well, Mr. Hill's not here, so he takes no position on it since he's not here. So I'm going to set your bond at $10,000 cash or surety. So if you can post a $10,000 bond, I'll let you go turn yourself in Franklin County. As long as you do that, then your bond would be discharged at a certain point. If you say, I can't post a bond, then I'm going to give them an order and a time frame in which they have to come down here and fetch you and take you back to Franklin County. Do you want to try to post bond yourself, or do you want me to order them to come get you?
Order them to come get me.
Okay. So one of the officers is usually listing in. So we need to have you go ahead and notify Franklin County he's available for pickup immediately. I'm going to give them a week to come pick him up. So that's a week from today is April 5th. So they need to pick him up before 8 a.m. on April 5th. So if you're still sitting in the jail on April the 5th at 10 o'clock, then I'm going to see you again by teleconference and decide, because I just don't want you to get lost. We've had people get kind of lost in the back of the jail, and people forget they're there. So this way I keep you on my docket, and I'll check to see. You'll either hopefully be gone, you won't be in the jail, and I won't have to deal with it. But if you're still there in a week, that means something went wrong, and we'll deal with it then as to what's going to happen. So I'm putting him back on my docket for April 5th at 10 a.m. Do you have any questions, Mr. Hicks?
No, sir.
Okay, we'll send this, what's called a waiver of the Rule 4 hearing, and I'm making an X where you'll need to sign, and it'll be sent back to the clerk for the record, just showing that you did waive the right to have the hearing about whether you should be made to go to Franklin County. Okay, that's all. Thank you, sir.
State of Ohio versus Cody J.W. Meade, case number TRD 22-2101 A and B, PRC 23-152 A, B, and C, PRC 22-1690 A and B, and Brent Pelfrey is on deck.
Your Honor, if I may, I arrested him yesterday on a bond revocation. He was being discharged from Cardinal.
Okay. Well, he has a lawyer, Mr. Smith, and Mr. Smith is OW, or is that WW? He's at Wayne County Circuit Court this morning, so I don't know if that's OW or WW. I think this is OW. But he says he'll be here by 11-ish, so I'm going to put Mr. Mead back on the docket after that. After he has a chance to talk to his lawyer, we'll decide how we're going to go forward after Mr. Smith gets here. So your lawyer will be here later. I'll have him call down, talk to you. After that's happened, I'll have you back on the teleconference, and we'll decide how we're going to go forward.
Yes, sir. State of Ohio versus Brent T. Pelfrey, case number CRB 22-450, A, B, and C. Donald Wilson Jr. is on deck.
All right, Mr. Pelfrey is at the jail. His lawyer, Mr. Steyer, is here at the court in person. He got picked up on a warrant by Mr. Sowers and taken to jail for failure to appear previously.
Your Honor, spoken to his family, they informed me today that he had an appointment with OVP for an assessment on the 9th of April. Since Ms. DeMint was here, I asked her to go ahead and speak to Mr. Pelfrey. They've talked to him. They are able to take him for treatment. He's spent about a week in jail at this point. I'm not sure what I'm looking at his case. Looking at the notes on his case, sounds like what he has left to do is
everything.
Well, he's got some community service and fines and court costs.
Well, let me just interrupt you and put this out there rather than wasting time. I only agreed to him going with an ankle monitor because he's failed to appear several times. And Mr. Sowers wants off the bond now.
Right.
So that's got it out the ante.
Do you understand, sir, that if you're released, you're going to be on an ankle monitor, and the reason I think we just lost the jail.
Yeah, we lost the video anyway. Is the jail still there? Apparently not.
Your Honor, since just to allow you to
call down and talk to him,
move things along, I'll call down there and speak to him and kind of update him on the situation.
All right, this case will be recalled.
Has to have this recalled once once the connection's reestablished.
And we probably need to start looking for a monitor right away. I don't know if you could even get one today.
I don't believe we can because I think the courthouse is closed.
State of Ohio versus Justin D. Hackworth, here at the court, case number CRA 23-613.
This is Mr. Smith's case. And Mr. Pelfrey, he can go ahead. Your lawyer is going to call down and talk to you, and then I'll have you back on the monitor after you talk to your lawyer. Could you hear me, Mr. Pelfrey?
Yeah.
Mr. Steyer is going to call and talk to you, off the record, well, at least off this record. Who we got next at the jail? Who would be on deck at the jail?
Donald Wilson Jr.
Donald Wilson Jr. next at the jail. Okay.
Yes, sir.
You're welcome. All right, Justin Hackworth is Mr. Smith is his attorney. He was going to mend his grievance.
That's my understanding, Your Honor. I don't know where he is. However, I possibly have this thing resolved today, unfortunately, or at least partially resolved.
Your Honor, Mr. Hackworth left our facility against medical advice. We reported this to Justin at the Adult Parole Authority. He was in contact with him, and he was, from what Justin told me, he was supposed to return himself to us within 24 hours, or Justin was going to issue a warrant. We did not hear from him, and I have yet to hear from Justin any further on the matter.
And this is a felony matter here, so how's the state want to proceed on it?
We can nolly this to the grand jury, Your Honor.
And I don't think he had an ankle monitor. I don't see any notes about an ankle monitor.
Yeah, I think.
All right. Mr. Hackworth had a felony that would have stayed in this court if he would have been successful in treatment and not gone to the grand jury for indictment, but now it's going to be taken to the grand jury for indictment since he left treatment against medical advice. So nolly to the grand jury.
Thank you.
You're welcome.
State of Ohio, excuse me, State of Ohio versus Donald J. Wilson Jr., case number TRC 072723. And Jesse Delaney is on deck.
And sir, are you Donald J. Wilson Jr.?
Yes, Your Honor, I am.
All right, Mr. Wilson, the record that I have shows in case number 072723, you got a conviction for operating a vehicle intoxicated. Also, driving under an OVI suspension and a lane violation were the three charges, and you were convicted of all three of those. That you had a review hearing in this court. Looks like it was March the 5th of 2008. And did not appear and got a warrant issued, which has been outstanding since that time. And I'm assuming that's what you got arrested on, the outstanding warrant.
Yes, Your Honor.
Okay, do you understand the charge against you?
Yes, Your Honor.
You have a right to remain silent. You don't have to say anything. You have a right to have an attorney, have one appointed if you can't afford one. No right to bail since you failed to appear, but you have a right to make the state prove the allegation beyond a reasonable doubt. Do you understand these charges?
Yes, Your Honor.
How do you plead to them?
I'm guilty, Your Honor.
Do you have an explanation for not coming to court when you're ordered to?
Your Honor, I'm not going to try to make excuses. That was 20 years ago, I believe, if my math is right. Back in 2007, I was living a totally different life than I am today. I was doing a lot of heavy drinking. That's not an excuse. I'm just telling you that's the way it was back then. I was drinking a lot, sleeping on friends' couches, not holding down jobs the way I was supposed to. Just didn't do what I was supposed to do. No excuse. That's what happened.
So what happened to cause you to get arrested on this?
Sticker violation on my car was what the original, what I was originally pulled over was for a sticker violation and for driving on a suspended license.
Okay, how long have you been in jail now?
I got in on Wednesday.
Tell me what's been going on with you now. You say you've changed your life, so are you working, married, kids? What's going on?
No, sir. No, Your Honor, I'm sorry. I'm on disability. I've had a lot of housing. I have 2 grandchildren that I'm helping raise as my own. Their mother and father are no longer in the picture. So we have adopted them. And I like to think that I'm making better choices as far as if I'm told to be somewhere, I'm going to be there. And I think I've grown.
Why did you not come in and take care of this before now?
I should have, Your Honor. I don't have an excuse for that. I don't have an excuse, and I don't want to try to make up a lie. So I don't have an excuse. I should have. Now I'm paying the consequences for that in a hard way, especially over the last, since 2007, my health has changed dramatically. And that's not me trying to be overly dramatic. That's to be proven through records. But I've got a lot of issues and problems. But I should have taken care of the problem. I'm not going to make an excuse as to why I did.
Where do you live now?
I live in Guyandotte, Riverview East.
Because back, well, at least the address that we had back then was on Rockwood Avenue.
I live at 225 Short Street, apartment 906, in Guyandotte, 25702, and that's Riverview East high-rise apartments.
Okay, can you post some kind of bond to guarantee your appearance?
I'm not going to lie there either, Your Honor. I have no money. I don't have any way of posting any bond at this moment. I don't have anybody to help me. My mother and father. My mother has since passed since I was up here in court in 2007. My dad's still alive. But there's been kind of a break in the family, so my dad and I don't talk that much anymore. So I don't really have anybody else to count on. I don't have a lot of income, so I don't have the means to post a bond. No, Your Honor, I do not.
Okay. Well, from what I'm showing, you didn't do any, I mean, you had 90 hours community service, almost $1,700 in fines and costs, and you didn't do anything that I can see.
Your Honor, I'm sorry. I didn't interrupt you.
Did you do any, I don't see that you did anything that you were ordered to do.
Your Honor, I'm not going to make excuses. I did not. Today's a different day. If given that second chance, I would be, I will report and do whatever it is that you tell me to do. I know that you can only take the face value on that, not my past behavior, but if given a second chance, I'll make good on this second chance.
Well, I get a lot of people promise me stuff that they never do. So I'm pretty cynical. Sorry about this. So I'd be willing to give you a chance to work, do the community service and pay the fines if I had some guarantee that you would have to show up. So if you posted a bond, then that means the bail bonds is going to come snag you if you don't come back to court. So I think that's what we're going to have to do if you don't want to serve some jail time.
No, I understand that. I just don't see a way clear of being able to pay a bond. I don't know what that bond will be, but I have no access to money at this moment. I live month to month. I get paid on the 3rd of each month, but I don't even have access to get to that money. So by being in jail, I don't have access. From what I understand, you have to have cash. So I understand your point of view, Your Honor. I don't disagree with you, but
Okay. Well, maybe if you were more motivated, you can figure it out how to get a bond. Because here's what I'm going to do. I'm going to sentence you to 60 days in jail. So, but I will allow you to post a bond so you can work off. I'd rather you get out of jail and do the community service and pay the fines or work them off. Because if you sit in jail for 60 days, the taxpayers of Lawrence County are going to cost them about $60 a day to keep you in jail. So that's going to cost people money, whereas if you get out and pay fines or do community service, you're actually putting something in. But I don't trust you to come back if I let you out and say on your promise that you're going to do it, because, well, heck, you never did anything you were ordered to do before. Why would you do it now?
Your Honor, the only difference between now and then, and I'm not trying to beg, but I was living on couch to couch, going from job to job. If I get sentenced to 60 days in jail and I'm not able to pay that bond somehow, some way, I'm going to lose that apartment that I.
And whose fault is that going to be?
Mine. That's mine. That's not your fault. I'm not trying to say that. I'm asking if there's any way it's clear to give me another chance.
I am giving you another chance by $150. You can't get anybody to come up with $150 for you. Will get you out of jail, but it gets me a bondsman who will come get you if you don't perform like you said you will. So that's what it's going to be. I'm sentencing you to 60 days in jail. I'll let you out on a $1,500 cash or surety bond, which will cost you $150, or whoever you can beg, borrow, and steal from to get $150. And then I've got some assurance that you'll have to come to court.
I understand.
So do you want to talk to the bail bondsman?
Well, I mean, I don't mind talking to them.
Well, if it would be me, and I had some relatives or friends or acquaintances or neighbors or whatever, I would be begging, 4 or 5 people to come up with $25, $30 a piece to get me out of jail so I can take care of my problem, rather than sit in jail for 2 months. I don't want you to sit in jail for 2 months, but I don't trust you to come back if I don't put the hammer on you. And you deserve it. You did nothing. You did nothing since 2007. You've done nothing. So if you have to serve the whole 60 days, you know what? That's some justice, because everybody else sitting out here, they're thinking like, well, if I get sentenced to something, why don't I just wait 10 years or 20 years and see what happens? I'll take my chances. Then I still have to do the same thing. Why would I do it immediately?
I understand, Your Honor.
Yeah, so I think I'm giving you a pretty good deal. But I prefer you get out of jail, because you know what? The jail's overcrowded. Is it overcrowded now?
I don't know the answer to that.
Well, is there people sleeping on the floor?
No.
Okay, sometimes and if you're there for 2 months, you're going to have some times where there's going to be people sleeping on the floor. You might be one of them. I wouldn't want to get, I've never spent the night there, but I've visited plenty of times. I don't know what you're thinking for since 2007, but in my mind, if I thought I was going to go to jail if I didn't do what I was ordered to do, you know what? I would crawl in here to do my community service or whatever I had to do to avoid that jail. I would not want to spend one night in that jail.
I understand.
People need to get scared about going to jail. Some people act like they don't give a crap if they go to jail or not. Well, to make them scared, some people got to go. So all these people are sitting there watching. I hope they're sitting there thinking, I don't want to be like that Wilson guy. I'm not going to jail when I could stay out of there. So you'll serve your purpose. Your purpose is to be an example to other people in a negative way. What can happen if you don't do what you're ordered to do?
I understand, Your Honor.
Okay. We'll have the bail bondsman come and talk to you. And if you can scrape up the bond, fine. I'm going to set your next hearing in 2 weeks. So if you get out of jail, I want to see you in 2 weeks. And no, I'm not going to make that 12th is a bad day. We'll make it on the 8th, April the 8th. So if you get out, you got to be here on April the 8th. If you're still in the jail, I'll talk to you again then. Hopefully you can make bond.
Okay, Your Honor.
Any questions about what you got to do?
No, Your Honor.
And when you talk to Mr. Sowers, I'm assuming he's the one that's going to give him the names of people that you think can post bond for you. He'll call them.
Okay.
You just need to be motivated, highly motivated to get out of that jail. April the 8th, your next hearing, and we'll put it on the sentencing docket.
Okay, thank you, Your Honor.
You're welcome.
State of Ohio versus Jesse L. Devaney, case number CRA 24-166A and B, CRB 24-167.
Lavonna James.
All right, sir, are you Jesse Devaney?
Yes, sir.
Mr. Devaney, I'm Judge Capper at the Lawrence County Municipal Court in Chesapeake. This is your arraignment hearing. You have a right to remain silent. You don't have to say anything. If you do make statements, it's on the record. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one. You have a right to make the state prove these charges beyond a reasonable doubt. Do you understand those things?
Yes, sir.
You've got 2 charges. They're both felonies. And these written charges were faxed down to the jail this morning at 10:33 a.m. So you should have them. Do you have the charges?
Yeah, he's here.
Okay. 166A case number is having a weapon while being under a disability. It's alleged that at Fayette Township on March 28th of this year, you were under a disability or not allowed to have or carry a firearm while being under indictment or having been convicted of a felony involving the possession, use, sale, or distribution of drugs. So that's a felony of the 3rd degree, having a weapon while under disability. The maximum penalty is 5 years in jail, $8,000 fine. The B case is possession of drugs. It's alleged that Fayette Township on March 28th, you knowingly were in possession of methamphetamine. That's a Schedule II substance. The maximum penalty for that is a year in jail, $2,500 fine. Do you understand these 2 charges?
Yes, sir.
Do you have the money to hire a lawyer?
Yes, sir.
Do you have a job?
Yes, sir.
I'll appoint Mr. Steyer. Appoint Mr. Steyer. He's here in the courtroom. He's heard the arraignment. What's the state's position on bond? And I'm showing a South Point address for you, Mr. Devaney. Is that right?
Yes, sir.
Your Honor, we would request a $10,000 cash surety bond.
Is that a bond you believe you could make? It would cost you around $1,000.
Not even, I just planned a room the other day to get some food and stuff. I have no money at all.
Oh, okay. So there's no cash or surety bond you believe you could make?
Yeah, I don't have no money at all.
Let me have just a second to speak to the prosecutor.
My bank account's in the negative. My bank is very much unloaded.
Your Honor, I don't believe we're going to be able to reach a solution to get him out immediately, so I'd like to set this for next Friday for a preliminary hearing.
Okay.
And at that point, we may revisit bond, but we also, or we can just go ahead and have a preliminary hearing if that's the state's pleasure.
At this point, it'll be set for a preliminary for April 5th, so a week from today. Bond will be set at $10,000, cash or surety. Anything else?
Your Honor, CRB 24-167.
Okay, I didn't see that. That's a misdemeanor, right?
Yeah.
Okay.
We'll waive reading and or plea of not guilty to that, Your Honor.
And we'll ask for a protection order too, please.
Oh, it's a domestic violence, so I'm going to enter a word. It looks, I don't think it's going to make a difference because it looks like you're going to be sitting in jail, so you won't be able to go around LaVonna Jones anyway. But in case you do get out on bond, I'm worried you not go around her or contact her.
Okay.
And not guilty plea is entered on that charge with a protection order.
Your Honor, was that April the 5th?
Yes.
State of Ohio recalls Britt T. Pelfrey at the Lawrence County Jail, case number CRB 22450B.
And this is Mr. Steyer's case. You had a chance to talk with Mr. Pelfrey?
I did. I explained to him, well, it's a minute thing. I explained to Mr. Pelfrey that if you allowed him out on an ankle monitor, that if he were to cut the ankle monitor, or tamper with the ankle monitor anyway, he would looking at a likely sentence of 3 years in prison. I've not known one of those cases to go up recently where someone hasn't actually been convicted. At the end of the day, it's not a terribly hard case to prove, and upon it usually results in a plea, and the plea is 3 years is basically what they do on those. So I believe he understands that and takes this matter seriously. He has he's spoken to OVP. OVP is willing to take him for treatment on an outpatient basis. He has
inpatient.
They said outpatient, outpatient, but
I'm not releasing him to outpatient.
well, he can do inpatient as well, Your Honor.
Will you take him on an inpatient?
Yes, we will.
Okay.
So he can
With an ankle monitor.
With an ankle monitor, and I also
Probably
explained.
isn't going to happen until Monday.
Yeah, I explained to him it's probably not going to happen until Monday because I don't believe there's anyone at the courthouse today
They're all home
to fit
praying
him.
and reading scripture.
Yes. So I would ask that we set this back. I don't know when you're setting cases at this point. I know we just set something on the
Want to
5th.
set it for Monday, just to make sure? Are you here Monday?
I'm not here Monday, so I'd rather, and Fridays he was pretty heavy, but if he's going to be getting out, probably Monday. I don't know, when are you generally wanting cases set at this point?
Well, for one like him, I like to have him sooner than later.
I could do the 5th, I'm here that day.
Okay.
I just didn't know if you wanted to work, well, he's getting overloaded.
All right, next hearing for Mr. Pelfrey's April 25th. I'll do an order. He can be released.
April 5th or 25th?
April 5th.
Okay.
That's a week from today, April 5th. It'll be on the pretrial for review docket. He's released on an ankle monitor to OVP whenever the ankle monitor can be placed, and that's for inpatient treatment. And I hope you understand the seriousness of this, Mr. Pelfrey, because it's not a joke. It's serious business, and if you cut the ankle monitor, you have just guaranteed yourself a trip to prison. So if you think I'm going to be really tempted to cut this ankle monitor, you'd be better off just saying, no thank you, I'll just stay in the county jail.
Well, I have no intention of cutting ankle monitor at all. Now, I understand fully how serious this is.
Okay. Well, very good. Everybody that I've had so far that we've discussed this with, everybody says the same thing that you do, but I've had 4 or 5 probably over the last year or two who cut the ankle monitor, and I believe every one of them is now in prison. Everyone that cut their ankle monitor is now in prison.
Yeah, I'm not cutting the ankle monitor. It makes sense to make more time for myself and go ahead and address the situation at hand.
Absolutely. I absolutely agree with you. That is the dumbest thing that you can possibly do, is cut your ankle monitor. But people still do it. After I've given them this warning that you're getting, they still cut their ankle monitor. So I don't understand it. And if you're going to do it, here, I'll give you a little advice where you can go and not get picked up. Argentina. Argentina does not have an extradition treaty with the United States, so go there. Don't go. The last guy that did it, you know where he went to hide out? He thought he was smart. He was going to go hide out and get away from the authorities, he went to Huntington. Yeah.
It is a long
Really hard to
place.
find. Really hard to find. Okay.
Thank you, Your Honor.
You're welcome. Okay, so we'll have to come back to the jail when Roger Smith gets back from Wayne, which
Your
hasn't
Honor,
happened yet.
Roger sent us a text message saying that his brother could handle his cases if it became an issue, so I don't know if it's an issue yet.
Well, he'll have to call, this is a person that's in jail. I mean, if he's gonna be here, I'd rather he handle it, but, you know,
I think he still intends to be here.
Yeah, I believe he made a contact with you, Judge.
he texted me this morning and said he'd be here after around 11, but I think he's contacted Mr. Hill and said it's gonna be later.
Yeah, he said, okay. Because he just texted me and asked if the court were okay. But I believe what happened is he's still in Wayne County. I guess his client was being brought down from the DRC and they were late getting him there. And so the judge told him to come and dock in Wayne County as well. So,
I went out there once for a hearing set at 9 o'clock in front of Judge Chafin. That tells you how long ago. And I didn't get my hearing heard till 3 p.m.
Yeah, I've had that issue before too. So I don't mind calling and at least the one that's in the jail. And if you want me to continue some of his cases, or I can cover.
I think this is.
Yeah, we've done several other cases.
Oh.
He's got some cases that are, I think, some treatment cases and other ones I don't think. But he was
Okay.
afraid that he probably wouldn't even get here till, maybe not until noon, because he's still waiting.
There may be some that Mr. Smith could help us with, and then if they couldn't, we could wait till he gets here.
We'll play it by ear. Let's start with this one and see where we go.
I'll call on this one.
State of Ohio versus Regina L. Hudson, case number CRB 23581, PRC 231382, A and B. Mr. Steyer's case.
Need Mr. Steyer.
Your Honor, this matter is one that there's been a great difficulty getting the videos involved on several different occasions. I don't think there's any intentional wrongdoing involved in this. We just had real trouble with the Axon system on this one. I've got an initial link to Axon, went there, it wouldn't let me, it I guess my account had been deleted, which I don't understand how that happened. I had to sign up for a new account, and when I did, it had no videos. So Ms. Dufour gave me a thumb drive with video. I got it to the office, it had some of all it had was the body camera video when they got to the post, but none of the body camera video during the stop. Ms. Dufour got me another thumb drive that had some of the dash video and that last part of the body cam video, but none of the body cam video with the section with field sobriety. Field sobriety was obviously done outside the car. It was not really visible from the dash cam, and for whatever reason, the dash cam didn't have any audio on at that time. It was only recording the interior of the vehicle. There was no sound going on. Mr. Heald today has given me a third thumb drive that we believe has the video of the field sobriety on it. I haven't had an opportunity to look at that yet because he handed it to me today. I'm going to take it to my computer to make sure that if I have the video, I can I can deal with the suppression issues. The main issue here is that I think a lot of the issues in the case come from the fact that Ms. Hudson she's not deaf but has profound hearing loss. And I think a lot of the things I read in the narrative maybe in the context of seeing it, I can say, well, some of these issues might be explained by the hearing loss, so I'd like to be able to explore that, and unfortunately, I just have not been able to do that yet. So I'm going to ask for yet another continuance on this. I know this has been getting long in the tooth, but like I said, we've just had crazy problems with the Axon system on this case, so.
Is she with QRT?
Oh, no, she is,
Helping her here.
Oh, okay.
she is,
I can hear him, but I wouldn't be able to hear you clearly.
All right,
she is Miss Dalrymple's aunt by marriage.
okay. All right, so we need to come back. When do you estimate you'd be ready to come back?
We'll give it a couple weeks. I know, like I said, we've been loading up these upcoming days anyway, so if we got a little bit further,
22nd?
22nd should be fine. Let me make sure of that. 22nd is fine, Your Honor.
April 22nd will be the next pretrial at 10 o'clock.
State of Ohio versus Williams.
Thank you, Your Honor.
Case number CRA 23703, CRA 23704.
William Price is Mr. Trent's case.
No, I forgot. I got a call from my attorney with my kids that morning. I was distracted. I forgot to get
Oh, okay.
because I'm trying to get my kids back in.
We had a letter last time.
Yeah.
But we didn't get one this time.
Right. Like I said, I hadn't.
Yeah. Your Honor, he wasn't able to bring a letter from Shawnee Mental Health where he is at currently. We can get a letter for the next one. He usually brings that himself because it's usually hard for the court to get letters from Shawnee Mental Health.
Well, the problem is, the last time he brought one, they said he hasn't been compliant with his appointments. So let me make sure I've read that right. He's not been engaging in counseling services, doing pharmacological management only.
Yeah, I think last time we were here, he had an appointment shortly after that. And he has been participating, correct? Okay. Everything?
Yes.
Okay. Also think it's also required in your other case too, is that correct?
No, it's not with my
Okay.
kids.
No, okay, all right, I'm sorry. He does have another case pending with his kids. I thought that was required in that, but it's not. So, Your Honor, we could come back relatively soon, and then he'll have a letter definitely that time.
Mr. Healy?
We're not opposed to that, Your Honor, and I realize that sometimes it is hard to get reports from some of these agencies. The alleged victim in this matter does say that, and the protection order was dismissed back in January, but the alleged victim says that Mr. Price's demeanor is much better, so that's a step in the right direction.
Okay. Well, that's good. April 22nd or 26th?
Let's do the 26th, Your Honor.
April 26th will be the next hearing. Preliminary hearing.
Okay, all right.
State of Ohio versus Nathan C. Beaver, case number CRA 21257. Mr. Stiers, please.
Oh, you already signed it.
Mr. Beavers with OVP and Mr. Benton not recorded.
Your Honor, he is compliant with his treatment at OVP in Gallipolis. And all of his drug screens are compliant as well.
Okay, very good. How does the state want to proceed?
The state's not opposed to a further continuance to allow him to follow through with his treatment and with the time limit.
Your Honor, we would be willing to waive time constraints to accomplish that. So,
I'm going to make it about 2 months then.
yeah, they come back on the time frame that you deem appropriate. So we're looking around the end of May.
May 24th?
I'm available that day. Is Monday or Friday better for you? Does that matter?
It doesn't matter.
Okay, May 24th would be fine, Your Honor.
May 24th will be the next hearing.
I'd like to talk to you.
Preliminary hearing at 10 o'clock.
Okay, so just hang in the line.
Thank you, Your Honor.
Just a minute or two in case I have another case called. Okay, thank you.
State of Ohio versus Dana D. Howard, case number CRB 24-148-150 and CRA 24-148.
This is Mr. Steyer's case, preliminary hearing and pre-trial.
Waive to maintain your bond. Waive preliminary hearing to maintain your bond, we talked about that there, so you don't get this. Your Honor, at this time, Mr. Howard would like to waive his right to preliminary hearing in order to maintain his bond.
Okay, Mr. Howard, you're giving up a probable cause hearing here and agreeing your case can go on to the grand jury for consideration. Do you understand that?
Yes, sir.
Okay, I'll accept your waiver. Case is going to be bound over to the grand jury.
Is that for both of the charges, Your Honor?
Yes.
Yes. Now, the misdemeanor will be knowledge to the grand jury.
Yes, Your Honor.
Sign your name here. Now, I'm going to give you the caution I've given a lot of people here lately, which is that we have two common pleas judges. One, go ahead and sign. I'm sorry. I'll let you sign, then I'll say it. We have two common pleas judges. One of those common pleas judges, if he's assigned to your case, I will likely be your attorney. I'll find out that you've been indicted. I'll get a hold of you and talk to you. The other common pleas judge, I'm very unlikely to be your attorney. You're going to get somebody who doesn't know you yet, doesn't have your phone number, doesn't have any way to get a hold of you. So it's going to be up to you to watch the indictments and make sure that if you find out you're indicted, that you find out when you need to be in court and get there. Because right now you have a bond that you're out on and you're free. If you don't come to court, they'll end up putting out a warrant for you anyway. So if I'm your attorney, like I said, I'll track you down. But if somebody else is your attorney, they won't track you down. They won't be able to.
If I go on with this today, does it matter if the defendant or the officer isn't here in the courtroom?
They're probably just going to annul it to the grand jury. If you don't, then you'll lose your bond.
Yeah, what would happen under those circumstances, the state would dismiss the case, and then you'd be free to go for now, but when the case goes on to the grand jury, then they're going to issue a warrant for you, and you'd end up arrested and have to make a new bond. What we're doing preserves your bond. It gives you a chance to show up on your own. And I'm going to tell you, I've been doing this a lot of years. It's always better when you walk in there under your own power and your civilian clothes than when they drag you in orange.
I believe that.
May I approach?
Yes. Okay, his waiver is accepted.
Thank you. Okay, you're free to go. Do you have another question?
Yes, Your Honor. Is there any way I can have the order lifted so I can go into my apartment and get my belongings and stuff?
Is she still remaining at that apartment, Jasmine, as far as you're aware?
Yes.
No. Can't do anything with that.
I have no clean clothes or...
Do you have a third party that you could send to get the stuff? Other than yourself, you have a third party you could send to pick things up?
I could find somebody.
Okay, you can text me that person's name, you got my number. I'll work with Jasmine, and Jasmine, if we get you a third party, can you make arrangements for the belongings to be delivered?
That's a whole apartment full of furnishing and stuff.
Well, I can't do anything about a whole apartment full of furnishing, but I can at least get you some clothes. I can at least get you some clothes for right now.
Okay.
All right, thank you.
You're welcome.
State of Ohio recalls Cody J.W. Dean at the Lawrence County Jail. Case number CRD 22-2101, AMV and others.
Okay, Mr. Tyler Smith is standing in for his brother, who has been Mr. Mead's attorney in the past.
Yes, Your Honor.
Mr. Mead was discharged from Cardinal.
Yes, Your Honor. I've talked with Mr. Mead a little bit. I think Cardinals discharged him. He's had some issues with getting some medication, his Vivitrol shots, which I think is supposedly, it's helped him over the last few years. The last one he had was in February. He's supposed to get a monthly, so he's been having trouble getting some medicines. But Leslie with Shawnee said that they could take him if we could send him to Shawnee, and they'll believe he gets mental health as well. If the court's okay with that, they could, I assume you have a bed for him?
Yeah, he's agreed to go back to residential as well, so he would have to start all over again.
They feel like they can help him, and the court feels like it's the right thing, we don't oppose it.
Is this with or without an ankle monitor?
He had an ankle monitor on at the time, Your Honor.
Well, I think he needs to have one then again. So that's probably going to mean Monday then before, I don't think we can get one place today.
That's fine.
And I want to ask them to put a more restrictive on him too, Your Honor. My understanding is this was because he snuck out of the facility. Was one reason why he was discharged. Was caught sneaking back in. So I might have to have a talk with the adult probation. I don't know why that wasn't reported.
Okay. And it was on the docket for April the 15th. We want to keep that date or come back soon?
That's fine.
Your Honor, that's fine. Roger said that he's available any day in April, so whatever he said, he'll be here.
Okay, I'll enter an order that he can be released to Shawnee for inpatient treatment with an ankle monitor in place. So a new one will have to be placed on him, and that's not going to happen until adult probation's back in the office, and they're not there today. So, and we'll keep the same hearing date that had been set previously, which was April 15th.
Thank you, Your Honor.
Thank you, Your Honor. Thank you.
That finishes us up with the jail.
State of Ohio versus James C. Skipper, case number CRA 2478. Mr. Stiles' case.
Okay, how did Mr. Skipper get to ODP?
Your Honor, he just went on his own and asked for an assessment, and
Yes, he did self-report, and I would like to add, whenever he was admitted, he did not fail for any illicit substances outside of THC.
So what's the, there was a dispute with Shawnee about some medication? What was the medication?
So,
whenever he gets prescribed medications, he can only take them at certain times. Just, we keep them behind 2 locked doors. And he was wanting to get his medications early. We were not willing to give them to him, and so he did ASA. But I would like to add that if Mr. Skipper finishes OVP, we would be willing to take him back for treatment again.
Okay. He has a felony. What was the medication in dispute?
Is it Wellbutrin?
Triliptal.
Triliptal.
Not familiar with that one. What's that for?
It's for schizoaffective disorder and bipolar, sir.
Okay.
It won't happen again, sir. You know, that was the stupidest thing I did, stupid decision made. And, trust me,
Hey, Your Honor, we don't like to see people jumping from treatment center to treatment center, but at the same time, I think there is something to be said for the fact that he, you know, once he cooled down, he realized that what he had done wasn't the best way of handling things, and he went and got himself somewhere. So I think there's something to be said for him for that. So I would ask that the court allow him to continue his treatment with OVP, and then when we get to the end of that, we can look at where he goes, where he needs to go and what he needs to do. And it sounds like he's willing to go back to Shawnee, and Shawnee's willing to have him back.
Mr. Healy.
Well, I think that what Mr. Steyer said is probably correct. At least he's found himself in a place, and he's willing to stay there at this point. And Shawnee says that they will take him back after he's finished the OVP program. So I guess that shows at least a willingness on Mr. Skipper's part to take part in this and avoid us taking it to the grand jury. So hopefully,
Why don't we come back on the 22nd? He'll be close to finishing it, OVP, and we can firm up the details of the next stage of treatment after that. So,
thank you.
Next hearing here, if you're available, Mr. Steyer.
I am, Your Honor.
April 22nd for preliminary hearing, 10 o'clock.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Destiny D. Anderson, case number TRC 23-1701, A and B.
This is Mr. Smith's case.
Your Honor, Mr. Smith, we actually spoke on the phone early this morning about this case, and he has a motion to bring to court today to file. And so we talked a little bit.
Reschedule for a pretrial on that motion because it's not in the file now.
Right, he'll be bringing it with him, I guess, when he comes. So yes, if we may reschedule for a pretrial.
Do we know what his schedule is?
Your Honor, any court date in April, he said he's available, so.
Okay. April 19th. The pretrial motion.
State of Ohio versus Nandy Joe Hall, case number CRB 24196.
Mr. Smith's case.
Your Honor, I don't know if, I believe there's a disc, I don't know if Mr. Smith filed discovery yet or not on this one. I'll just ask.
I don't see anything.
Yeah, so I'll ask to continue it couple of weeks, and then I'll have him, let him know we can file discovery since there's a disc.
April 26th. For pre-trial, April 26th, 10 o'clock.
State of Ohio versus Walter Panel, case number CRB 2423.
Does that answer?
Your Honor, if I may, he has done 42 hours of community service.
Okay, thank you for that report.
And I was kind of confused, so yesterday I was trying to get a report for him for OVP, and I called all of our outpatient offices, and none of them were familiar with him, so I was unable to get any information. He wasn't in any of our, like, computer systems or anything like that. He's telling me now that he did go and get the assessment at Huntington, so I can follow up on that to see if maybe they missed it somehow. But, I mean, if he's done all of his community service and everything, maybe he did do it.
He's advising he went to OVP, so when did you go?
It was whatever day they told me to. I was like, I can go back and look, but I know it was.
Last time you were here that day?
After, like, the Monday.
Oh, okay.
The week after.
He advises he did get assessed at OVP, so I guess we just need to find out what happened with the assessment.
Well, I think it's commendable that he's done 42 hours of community service. I don't know exactly if we had a number that we expected, but we also wanted to make sure that he got that counseling that we felt was necessary. So I don't know if he's been going to OVP. Hopefully they can figure it out.
Well, he said he just went and got the initial assessment, is what he told me today, but they didn't have any record of him, so I'll dig a little deeper to see if I can figure that out.
I had a note 40 hours.
Yeah, do you have the correct spelling of the name? So I
40.
Check that.
But he's done 40.
And is he getting treatment with other providers? Does he have any other current providers?
Who? Prestera? Valley Health, okay, Valley Health.
The council want to approach?
Yes, sir.
Oh.
April 29th is the next one.
That's fine, Your Honor.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Jason L. Turner, case number CRA 23638, PRD 231050, A and B.
Okay, so, and one of the things being decided today is whether his ankle monitor could be removed today. So,
I would recommend it.
okay. Mr. Healy?
We're not opposed to that, Your Honor.
Okay, I'll enter an order that his ankle monitor be removed. You'll be with Mr. Major about that, getting that done today, and then come back in another month or so.
Your Honor, that may be Monday before it can be removed.
Yeah. We can't do it here, so.
I don't think so.
Okay.
It's maybe, I'm not sure.
You'll need to talk to Mr. Major about it. April 29th will be the next one.
Thank you, Your Honor.
State of Ohio versus David L. Mills, case number CRA 249, CRB 23758.
This is at RRS.
Your Honor, he's doing very well within the program.
I take it this is Ms. Hoffman.
Your Honor, I've been speaking with Ms. Hoffman, and she recently gave us some more evidence, and it's pretty compelling. There's a felony charge pending in this, and sometimes when a charge of disrupting public services is associated with a domestic violence case, it's almost like we toss that aside as if it's not as important. But sometimes it is as important. What I want to do is have a discussion with Ms. Hoffman when we don't have to whisper. I can meet her in our office or on the phone and talk about what we need to do in the future, but we are definitely not willing to decide that if he does well in treatment that the charges will be dismissed. So I guess what I would ask for is just let him continue in treatment for the time being. We come back in a couple of weeks. In the meantime, we'll decide how we want to proceed, whether we want to take it to the grand jury or whether we want to do something that results in the case being kept here.
All right. Right, yeah, I agree with
That's
that.
fine. If we can come back in a couple of weeks, we can continue with treatment. He's doing well in treatment. It's just one cause.
Okay, yeah, I thought I was getting charged each time.
We're going to make it April 22nd. Any in treatment, we'll see you on April 22nd.
Thank you. That's an entry.
Oh, ladies, I thought it was a...
State of Ohio versus Haley Early, case number CRB 2480. Set for sentencing.
All right, Ms. Early is here. She doesn't have counsel. Entered a plea of the life sentencing. She's at OVP. I've been getting reports.
Yes, I emailed you her report, Your Honor. I wasn't able to print it off before coming in here this morning, but she is compliant with OVP, and we're actively working on getting her into Project Hope, so she is on the waiting list there. She has gotten visitation with her children, and she's just progressing well at OVP, so we're just waiting on Project Hope, and she'll just remain at OVP until she gets to go there.
I texted one of the directors there yesterday and told them what's going on with you and your family. And they, Ms. Gogus, and she agreed to move you up. I guess there's a priority for women who are pregnant.
Yes.
And so some of those people are ahead of you, but she said she would move you up so you would be next in line after the women who are pregnant or waiting to get in the program. So I understand it's a difficult situation with your great-grandmother taking care of these children, but I think under the circumstances, this is the best thing. But I want to get you there so you can have your children with you and be in treatment, and I think that's a great program and a great opportunity for you. So we're working to try to make it happen. I want you, we had a discussion last time about our goals, and I think they're the same. And I want to keep you in line to achieve those goals. And I think you're on the right path now. But you got to keep working and keep positive attitude about this and a change of mindset. And I think that's some of the things you're working on, right?
Right.
So, and she will not be discharged from OVP as long as she's waiting for Project Hope, is that correct?
Right, yeah.
But
But will be discharged as soon as the bed's available.
Yes.
So hopefully that's soon. Okay, why don't we put her back on the docket for April the 8th, so I can keep track of this. Okay, your next hearing is going to be April the 8th. Keep doing what you're doing in treatment, and think you're doing well, but we got to keep working, right?
Yeah.
Okay, we'll see you April the 8th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Rebecca L. Blankenship, case number CRB 2486.
He doesn't have these. Okay, yeah, and this. And I wanted to read what my everybody said about me. I did really good in there.
She did, Your Honor. She has completed our inpatient recovery center.
While doing full-time school as well. And that means I attended every single meeting from day one, from 8 o'clock in the morning until 8:30 at night, sir. I also got peer mentor because I was, out of 70 women, I was the only one that didn't get an MRP, and I never missed a class. I took it very serious. Yeah, I'll do outpatient at OVP. But they told me to go.
Well, that's good. And your paperwork all looks good that you completed.
I even got
It's gonna go
A's.
in your file. I want you to do a urine screen today and then come back and decide how we're going to go forward.
Thank you, sir.
Okay, go
And
do
may I
urine
just
screen.
say one thing?
Yes.
It was the first time I've ever been away from my children, and it was really hard on me. So I apologize, and I just hope that you will let me be easy on me, please, sir. I've tried so hard. I've tried
Let's
so
go do a urine
hard.
screen and see what it shows me.
That's fine. It'll be 40 days today, sir.
State of Ohio recalls Alec R. Berry, case number PRD 24611.
You're Alec Berry?
Yes, sir.
All right, Mr. Berry, it's alleged that March 26th at 5:31 p.m. in Perry Township, you were operating a vehicle while you were under the influence of alcohol or drugs, and that you refused to take tests. It's also alleged that you've had a prior conviction for an alcohol-related driving offense in 2023, so that would make this a second offense. The maximum penalty for this is 6 months in jail, $1,625 fine, and a 5-year license suspension. The minimum penalty is 10 days in jail, $525 fine, and a 1-year license suspension. Do you understand the charge?
Yes, Your Honor.
Do you understand your rights?
Yes, Your Honor.
Okay, it actually is not an OVI, it's actually being in physical control of a motor vehicle. So that is a first-degree misdemeanor. The maximum penalty is 6 months in jail, $1,000. It's not an OVI.
Yes, sir.
It's a serious charge, but it is a serious charge.
Yes, sir.
How do you wish to plead to this charge?
Not guilty.
Do you wish to have a lawyer appointed to represent you?
Yes, Your Honor.
You have a job?
I'm not working at the, I'm in a union, but I'm just not I haven't been able to find no work.
When's the last time you worked?
Couple weeks. No,
Your Honor, he was in residential treatment, completed the whole program, had this relapse, and I just got him reassessed yesterday, actually.
I've not worked since I started residential treatment on the last charge, Your Honor.
Do you have a prior case in this court?
Yes, Your Honor.
Yes.
Does he have anything still pending?
So, I got it. Yes, Your Honor.
Who's his attorney on that?
Stratton.
He's already gone. Mr. Stratton's already left, I think.
Yeah. Tyler Smith is here.
Okay, I'll appoint him. I'll appoint Tyler Smith to represent you. Now, is he back at RRS?
Yes, on an outpatient basis. Outpatient.
Was he inpatient before?
Yeah, he was inpatient and completed and had this relapse, and I got him in quickly to reassess. He's on a color code randomized urinalysis system, doing 3 groups, 2 individuals a week.
Okay, one thing is I see on there's no proof of insurance. I'll enter a not guilty plea. As a condition of bond, I'll let him sign a $1,500 OR bond to remain in treatment with RRS.
Your Honor, I have proof of insurance on my phone if that
Okay.
matters, or
You can discuss that with Mr. Smith. And let's set the next hearing. What's your schedule?
The only date I'm not available this month is the 26th. I'll be in trial that Friday.
Okay. Let's do the 29th.
Okay.
April 29th.
So, Your Honor, do I still show up on the 8th be here for that as well?
That was a review on your other case, right?
Yes, sir.
Yeah.
Thank you.
Thank you, Your Honor.
Thank you, Your Honor.
State of Ohio recalls Jason Collier, back in holding, Your Honor, case number CRB 22275, CRB 22222, CRB 22271, CRB 21885, A and B.
Okay, Mr. Collier, what have you got to say?
I'll make a payment today, I'll make another payment Monday.
How much?
I'll pay it.
Okay. And when can you get here? You're gonna go to ATM?
Yeah.
Okay. I'll set your next hearing for April 29th. The $100 payment made today, that's gonna go to restitution, the restitution on one of these cases to a party or a defendant or a victim. Okay, April 29th is your next hearing, 9 o'clock. You're welcome.
Thank you, Your Honor.
Sorry about that, Judge. State of Ohio versus Matthew Sawyers, case number CRA 21-562.
Mr. Smith's case, preliminary hearing.
Your Honor, I represent the treatment facility. Can I stand with the client? I represent the treatment facilities in the building.
Yes, sir. What's your name, please?
David Jackson, PRSS.
What's the name of the facility?
Shillian Circle of Care.
Thank you, sir.
I have a written report, Judge. Mr. Hill's looking at the original. Can I approach?
Yes. Okay, Mr. Sawyers has a relatively old possession of heroin charge from 2021, but it's relatively old because he failed to appear back in August of 2021 for a hearing, and there's been a warrant outstanding since then. And it looks like, I think he came in on his own to get it cleared
I
up.
believe he did, Judge, a week or so ago.
Yeah. So we've got a report that he's been in a long-term treatment for almost a year now.
Yes, sir.
So how do you propose to go forward, and how's the state propose to go forward?
I know that he's eligible to graduate any time now from the program, and then it's my understanding he has been recommended he seek aftercare, which he's willing to do. Is that correct?
Yes, sir.
I think as far as the program completion goes, that I think he could graduate any time, if I'm correct.
Yes, sir.
And then begin the aftercare program. I don't know if we want to monitor it.
What's the state propose?
Well, the fact that he's nearly completed a year-long program goes a long way. I guess our only question would be, should we see him across the finish line, make sure he finishes, gets into the aftercare. So we propose maybe one more hearing to see.
His only concern, Judge, is employment. He's unable to get employment
A pending case.
if there's a pending case.
I start orientation on Monday
Where at?
at CAMC Memorial in Canal City.
What are you doing?
Environmental Services, janitor.
Your Honor, it was a situation where we understand that he's been charged with a crime and he has to do exactly what you want. But what was going on, we pride ourselves in getting clients prime jobs, and we were able to get him a job, a good job at a hospital, And what happened, when he was going through the orientation phase, they tell him he had an open case here that he had to take care of. So immediately, we came to take care of that. So what's going on, they're kind of holding the job pending a disposition of the case, so they won't hire him unless it's been resolved, and if that can't be done that day, we understand, because he has the obligation for this, but that's what we were seeking, so he can start work, but whatever you see fit, Your Honor, we're satisfied.
Your Honor, I think Mr. Sawyer's in good hands with this organization. So, and he's been through nearly a year program, and he's got a chance at a good job. So if we're holding that up, I don't guess there's really any good reason to. So we go ahead and move to nollie that charge.
Okay, so what that means, they're going to dismiss it, but it's with the right to refile if you mess up, so they can bring this charge back if they get word that you relapse or whatever. They could be a mistake, they could refile it.
Yes, sir.
Your Honor, if you would like us to send you some documents at a certain date, how he's doing, we're willing to do that, whatever you, just give me the instruction.
At this point, it won't be necessary. I have the documents that have been filed today, so we'll be dismissed with the right to refile down the road, but with the hope that never happens.
Yes, me as well, yeah. I've been traveling back and forth from Ohio. I hope, free of charge, I hope he gets there. I believe in him, that's why I'm here with him today.
Okay, thank you for your support.
Yes, sir.
The only question he had, Judge, is that, and I know it's probably a shorter day, possibly get the order today so we can start Monday?
The order will be filed today. So
Perfect, you can go online.
Yes,
great. So you get a copy of it.
Okay.
That way you have before Monday, you're.
All right.
Thank you. Appreciate that.
You're welcome.
Good luck to you.
All right. Thanks, sir. Thank you, Your Honor.
Truly appreciate your service, Your Honor. Thank you so much.
Yeah, Mr. Smith, I've signed the order. You want to assist him in getting it from the clerk? Not now, but at the conclusion of court.
Okay. Just wait for me. I'll be a few minutes.
Thank you. Your Honor, I understand that Mr. Smith would like to see Cody Mead recalled in order to change the date. I don't have the folder still, but the only reason was that we supposed to change the date.
She's unavailable. That's okay. Apparently, she's not available the 15th. What if we do the 22nd?
That's fine. We still have this file.
I'm sure it's in the docket.
Okay. I'll change it to April 26th. Cody Mead will be set for April 26th.
I'm available. Appreciate that, Your Honor. Thank you.
Thank you, Your Honor.
State of Ohio versus Emily McCoy, case number TRD 193655 A and B.
All right, Mr. McCoy's on the sentencing docket. She's been amended briefs.
She's indicating to me, Judge, she is graduate. I guess we're going to get confirmation of that.
Permission to approach, Your Honor.
Yes.
Thank you.
This week, 26th. Are you here?
Yeah, I'm going to stay in with outpatient, and I'm going to, I have a 30-day extension, and I'm going to do transition from
Well, she completed the recovery program, so I understand she's going to stay in sober living.
Yes, I applied for a 30-day extension of my own. I want to continue to stay there and allow them to help me transition back into the community independently.
Okay.
Judge, I would ask, she does still have the ankle monitor on. Would this be appropriate time to take the ankle monitor off?
Oh, she still has an
She still does. She
Yes,
asked me if
sir.
I would address the court.
Is that recommended, or?
We have no issues with her removing her ankle monitor. She's been doing fairly well, plus with the graduation and the intent to stay for transitional, we would be willing to recommend it be removed.
Okay, I'll enter an order that the ankle monitor be removed. Now, it's going to be an issue whether it can get done today. I'm not sure if Mr. Major can do it or if he has to have adult probation. They're not open today, so.
Correct.
But you go confer with him and he'll either do it today or make arrangements to get it done. Might be Monday before it can be removed.
Thank you.
And then I think we should keep monitoring.
Sure.
Anyway. She still has quite a bit on her fines and costs to pay.
If I could say, I did file my income taxes last week, and with the amount that I'm getting back, I'll be able to pay that off in full, and I entirely plan to do so.
Okay. I'll set a hearing in May.
Yes, sir.
May 6th, are you available then?
Yes, I should be, yes.
Pre-trial review. Sorry, it should be a sentencing. Sorry, apparently she does have a bond. So May 6th for sentencing, because that's what it should be. Sentencing hearing, May 6th.
Thank you.
Thank you.
Okay, you've done well. Congratulations.
Thank you, and I want to thank you too. This has been the best thing that's ever happened to me, getting myself back and my family.
Great. Keep it up. Keep working.
Thank you.
State of Ohio versus Stephanie Kingsbury, case number CRB 18826.
Mr. Smith's case.
Yes, Judge.
Sentencing, because there's a bond.
Okay.
Oh, she's paid her fines off.
Your Honor, I just printed that out.
Okay.
Yeah, I was unaware of that. Okay. Is she still in community service?
I knew she'd done something in service, I wasn't sure how much that's on.
I'm showing she has 3 days left. Is that right?
That's all right. Community service.
I can finish those as soon as I get my car legal.
Yeah, she says she has to get her car legal, but obviously she's going to do those days.
Yeah, I want to get those done ASAP.
The computer's just showing she has $20, so it's going to chance to look at it.
When you get the car going.
The only thing that I need is the sticker, which I'm waiting on in the mail, and then I'm ready. It should be sooner than that.
Yeah, she still has $20. She paid $4.98. Well,
Paid $630.
there must have been a warrant fee or something.
Sheriff's fee,
Okay.
$223.
623.
She paid,
$4.98.
so 623 on this phone receipt, I don't know.
Or actually,
Is that for this one?
641.
Oh, 641.68, I guess, with,
Some go in another case. Does she have a receipt?
it's on her phone.
We give phone receipts?
It's a confirmation.
I did it online.
Yes, LexisNexis and a confirmation number.
Yeah.
Judge, I submit to the court, the total amount showing paid is
There must have
$641.69.
been more than just this case.
He had LexisNexis charge her $18.69 convenience fee, or whatever that is. And the principal she paid to the court was $623 through a Visa transaction.
Stephanie.
There was a receipt on this case on 221 for 125.
I think it was 221.
Do you have a different last name, ma'am?
No.
What's the date on that? I couldn't find the date on it, Judge.
Yeah, there was a traffic case too. $125 went on, it looks like.
220.
This is showing 2/20 of 24 at 9:33 a.m.
You wrote your social name?
Yeah.
498 was put on
This case.
This case, Your Honor, 18826.
You can pull that back. Social, show all of them.
No, I'm
Yeah.
going to have to look at each individual case. but I only see 2 cases for her.
Okay, but there was a payment of $125 on April, or on February 21st, I think, on that traffic matter.
Oh.
It was an 09 case.
498
There was another case here as well.
So that would equal the 623 if you paid 125.
You had another case too. Stefan, there it is. That one showed 125. Yep.
498 and 125.
She was showing 623 as the payment. plus
Yeah,
the
she
fee.
had an old traffic case from 09,
Okay.
2767. So that's where the other money went.
Judge, she says her car should be repaired. I said 2 weeks. She said probably sooner than that. If we could come back in a couple weeks, she says she will knock out the community service and.
Well, let's plan on more.
Okay, I'm not sure what's wrong with the car, but that was her estimate. You never know.
April 29th.
I'm here, Judge.
For sentencing. If she gets it done, she'd have to come back.
So give it Josh, as you got that car working. I'll hook you.
State of Ohio versus Jeremy A. McMillan, case number TRC 22769, A, B, and C. TRC 202410, A, B, and C. TRC 142341, A, B, and C. Jeremy McMillan.
What's going on
I have the report from Bethesda, big screen. You're working now?
No, sir, I've got about 4 applications in. They're all waiting on my background check.
I thought, because I had you a job at Superior Marine.
The day that I had my physical for them, I was in the hospital with my knee locked up. There was no way to get there, and then when I did, I wasn't going in there on a crutch. So when I went back 2 weeks later, he told me he'd hired. So I'd called that Jason dude several times, but I didn't want to go in there and make him hire me, because then that would have been a bad relationship. I call him once a week. I've got a guy in our house that just got hired down there.
Well, because the owner asked me, and I told him that you got a job someplace else. He said, what happened to Jeremy?
Well, I mean, I'm working at that farm. I really don't call that a job. I've been working 12, 14 hours at that Freeman farm. But I've been doing that for the last 4 weeks, but that's not like a real
You want to
job.
go to work at Superior? I can probably get you there today.
Yeah, but I would love to, but it's the relationship thing. I don't want to be forced on. I'd like to be.
Well, I can trap that relationship.
That's what I know. And
You just say the word. And it doesn't matter what Jason says, because I'm going to go to the owner that I'm going to have dinner with on Sunday.
Yeah.
And he asked me specifically, last time I had dinner with him, he said, what happened to Jeremy? And I said, well, Jeremy told me he got a job someplace else. Or at least that's what I was told.
No, when I went down and talked to him, he said he had done hired, and I said, well, stay in contact with me, anything general. And I call him about once a week. He hasn't responded. So I was just like, well, if I have the judge call down there and Matt makes him hire me, it's going to be awkward. But yeah, I'll go to work. I'm actively looking. I've got a couple in at Lowe's. That's a good one. This makes for a bad relationship. They make me, you will hire him. You're my boss. I've been in that predicament before.
Before I hit send, I'm going to read this to you, and you tell me whether it's okay to send this or not, okay? And I want the truth. Okay, so this is on to Matt Mans, who's one of the owners at Superior Marine. And he said, I'm going to say, here's what my text says. Jeremy McMillan is ready to come work for you now if you're ready to hire him. I can have him there within 2 hours at whatever time you tell me.
I like how you said, if he,
Want me to
yeah.
send that?
Yeah, I
So
like,
if he sends me a text at 10 o'clock tonight, I'm going to text you and you're going to be there before midnight, right?
If that's what it takes, yeah, I can work there.
I mean, you got to do whatever it takes,
Yeah,
man.
I can do it, yeah. I just didn't want
That's
it
the
to.
role I want you to get in, you know. Whatever I'm going to do for this job, that's what I'm going to do. No excuses. Get it done, okay?
If I get the job, I hold them. I've worked 7, I'll keep the job.
Well, I understand, I get reports that you're a really hard worker, but no excuses. No, well, I gotta lay off today because my nephew has a Little League championship game, or whatever, you know. People don't want to hear that crap. They want you to be there and do the job, or I got the sniffles, or whatever. Do the job, okay? And you're gonna do it.
Yeah.
Okay, because I bragged on you to Mr. Mance, so I want to see some performance. I don't want any excuses. So if he tells me the word, then I'm going to get it to Kim, and Kim's going to get it to you, right? Because Kim knows how to get a hold of you.
Everybody here knows how to get a hold of me, yeah.
24/7, she can get a hold of you, right?
Oh, yes.
You're telling me yes?
Yes, sir.
Okay, I'm hitting the send button
Hit
right
it.
now. Okay, there it goes. And let's come back, because I've got, Judge Ferguson hasn't retired yet, and I'm in Huntington every day. So if I get in trouble with him, I could be out at Western Regional,
Got no more
looking
about
out from
that.
behind bars, and I don't want to do that. So I got to keep him happy, and I told him I was going to be watching you.
I did get to turn some paperwork in to Jennifer, the completions and all that good stuff, so that was good to see that.
Okay, so April 29th?
Yes, Judge, be fine.
Okay, April 29th. Now, if you get the job there at Superior and they say, no, he's got to work April 29th, then I'll change it.
Sounds good, sounds good.
Thank
you. Thank you.
Okay.
Thanks, Judge.
Keep looking at your phone, because hopefully I'll have some word for you.
Thank you.
State of Ohio recalls Rebecca Blankenship, case number CRB 2486.
Excuse me, sir.
No? No, I'm a little concerned. It's better than her screen was February 23rd. So what's the plan now? She's finished inpatient. Is there going to be any
Yes.
follow-up?
She's following up with OVP outpatient in Huntington.
Okay.
And I told her that we would continue to follow her for a while, and she's in a, she's agreed to that.
Did you see the result on the,
I did not.
it says a faint line on fentanyl.
Oh, okay.
So hopefully that's a remnant.
Yeah. That don't make any sense.
But that's one of the things you were positive for in February.
Yeah, but I promise I have not done anything, sir.
Okay. Well, you know what? Time's going to tell.
Yes.
Yes.
Time will tell.
Is it possible that like Seroquel could do that or anything?
I don't know. I'm gonna give you the benefit of the doubt.
Thank
but
you, sir.
I want you to come back. I want you to continue with the outpatient.
Okay,
So I'm just gonna go ahead and sentence you, but that's gonna be part of your sentence.
okay. Thank you, sir.
Is there a sentencing entry in the file?
No, I've never sentenced her yet. I just delayed sentencing. She pled before and I delayed sentencing in order to treatment, and she did it.
Was it taken
With
out?
flying colors.
So she was sentenced on February 23rd, so.
She was not.
I went in on February 23rd.
That's when she went to inpatient treatment.
Because I had court with you that morning, and I said I'd be there by 5 o'clock, and I was.
Yeah, it's kind of like, they made a note to themselves, it's not really a judgment.
But I'll deal with it later.
Okay. Anything else you want to tell me about this?
I just wanted to thank you, sir, for everything that you did. You've probably saved my life. Obviously, I have had like sleep apnea and a lot of other, things going on, and I should have never took a sleep medicine from somebody because obviously there's all kinds of things in them, so that was definitely a lesson learned. But I am now on all my medications again, and I feel
And you
great.
can get those all from OVP, right?
Yep, that's correct.
Okay.
Yep.
They can handle all, whatever your medical needs are, they can evaluate and give you appropriate medication, not
That's-
street medication.
That's right. And also, I did it with nothing. So I'm not on Suboxone or anything.
Okay, that's
And I
good.
don't have any type of, urges or anything like that.
Okay. Well, I applaud your efforts so far, and I want to see you continue to be successful. You got to keep working at this. You can't, it's
Yeah.
not
I understand.
totally over yet.
Yeah.
So,
That's okay. Whatever you need me to do, sir, I will. And I've actually, in the last couple months, I've decided to not stop there. I'm going to keep going for my master's.
Okay, well, that's a good goal.
Yeah, it's a lot on me.
So I applaud all that and wish you the best. I want you to be successful.
Thank you, sir.
And your sobriety is the key to that.
Yes,
You know,
sir.
you can't accomplish any of those goals if you're not clean and sober.
And you're absolutely right, sir. You are.
Okay, so I'll impose a $100 fine on your theft offense, or you pay the court costs. 30 days in jail, all suspended. So I'm suspending your jail time
Thank you.
on the condition that you stay clean and finish treatment with OVP outpatient.
Okay. And how long do you need me? I mean, I plan on staying there since I'm on the medication.
Until they say you don't need to come back.
Okay. So what do you want me to do then?
I'm going to set a review hearing, and you'll come back and give me a letter from them, or Brianna's here every court session just about, so if you're here and she's here, she'll give me a report. She can check at any time and see what you're doing or not doing.
Okay, sir, thank you. I'll make you proud, I promise.
So, let's make it your next review hearing. June the 3rd.
June the 3rd, let's do it.
Yeah, so that gives you a little time, a little breathing space, but not too much.
Yeah, thank you, I appreciate it.
I'm going to order also that you do 5 days community service. We've got a community service program here at the court.
Okay.
And Mr. Major will talk to you about that. You're going to be on probation for 2 years.
Ooh, okay.
But it'll be non-reporting basically, other than the review hearings. And once you're finished, that'll be it. You know, if you get finished before 2 years, you'll be done. It's just,
Okay.
it's a way for me to make sure you do what you're supposed to.
So what do you mean if I finish before the 2 years?
If you finished your community service, paid your fines, and OVP says you're done, you don't need to come back for any more counseling with them, then I'll terminate your probation then.
Okay. But what if I want to still continue to see you?
Well, anybody, I can walk in tomorrow.
Yeah, I got you.
Anybody can go at any time if they want to. And
Okay.
If you feel like it helps you and you want to continue to do it, I'm not going to stop you from doing it. You can,
Okay,
you can
thank
keep
you.
going for counseling. Okay, so Mr. Major's in his office to the left as you leave the courtroom. So talk with him and get some paperwork, and then you're free to go after that.
Thank you.
Congratulations, you've done
Thank
well
you.
so far.
Thank
Keep it
you.
up.
Thank you, Your Honor.
Thank you. Let's go.
Okay, court is adjourned. Oh, treatment providers, we're going to have a meeting Monday morning. Yeah, that'll be April 1st, Monday morning at 8:30, right here. And bring Ronald's birthday present.
I would almost bet money.
She used to flush her system, I bet money on it.
Well, maybe I should have said her sooner.
Have a good weekend.
We'll see.
You were right, time to tell. Yeah.
Oh, awesome, thank you. Philip, can I get your signature?
Well, I probably should look here so I can see what sometimes they said stuff and they don't
Did you just get your? Yes, I did.
I heard it.
Ditches.